Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How are you? How are you doing? Sorry to be early. I know it's not right. The universe is misaligned. Sometimes the stars align in such a way that I can actually do something correct. So what's up, guys? How's your day going? I hope it's going well. My day's going pretty well. We've got some stuff to cover tonight. We're going to be covering updates in the Melinda Scott versus Joshua Connor Moon case tonight. That is the Kiwi Farms versus the Chosen People of the Mountains. And we will see how that goes. It's not the longest update there. It's a couple pages. It's a response to Melinda's motion to recuse. I'll let you try and guess whether or not Josh and his lawyer agree with Melinda or not. You can sit in breathless suspense while you wait to find out the answer to that question after we go through that document. After we go through that document, we will then delve into some courtroom drama. We'll watch some. I've got a couple videos queued up of court cases. Excuse me. Can I not yawn? One we previewed the other night. Talked about it. It's a CPS lawyer who is going to argue to an appellate court panel that CPS agents had the right to lie to the court. That was fine. So we're gonna watch that one. And then the other one I've got, what is this? This is from Not the Babylon Bee. It was sent to me by Bitcoinity fan on Twitter. Oh my God, what? I haven't been yawning all day. I get down here and suddenly it's just yawn, yawn, yawn. What is this? It was sent to me by Bitcoinity fan. And it says, during serial girlfriend beater's courtroom hearing over Zoom, lawyer discovers the scumbag abuser's in the same apartment as his victim. So we'll watch that in a little bit as well. Let's see, how long is this one? Okay, this is a couple minutes. Who knows? So we'll watch that. And then, we'll see where the night takes us. We'll see where the night takes us at that point. But let's see. What do we got? What's going on? What's happening? There's a chat or two that came in before the thing, and dumb feature of YouTube to remove the chats that come in early. I don't understand why they do this. So anyway, Sleepy Gaunt says the YouTube app isn't letting me type my message or allowing me to do a 20-pound chat. Just wanted to make a Kermit voice request and thank you for your streams. And follows up with, it was going to be a little joke for me to play back to a friend of mine later. If I send it as a normal chat, could you do it, bud? Yeah, I can, Sleepy Gaunt. I can do that. So you got to tag me. Let's see. Let me set up the pinned chat. This stream will be uploaded to the archive channel. YouTube.com/Ricada Law Live. Let's see. There we go. So there's that. Okay, here it is. Excuse me. Goodness. Mother. Here we go. Sleepy Gaunt says, hey there. Kermit here with a reminder that you demon hunters ain't gonna do shit when that Rhett Pally comes in dick swinging you pussies. Wait, what? Hold on. When that Rhett Pally? What's a Rhett Pally? Is that Paladin? I got it, but is that from World of Warcraft? Hey there, Kermit here with a reminder that you demon hunters ain't gonna do shit when that Rhett Pally comes in dick swinging you pussies. There you go. Hopefully that's a little bit better. Well, so there. Oh, Retribution Pally. Okay. Breathe more and you'll stop yawning. Normally everybody tells me to breathe less. So I don't know. I don't know which advice to take. Lost Bullet says, listen to my heart on Echo today. It sounds like Lizzo and Marky scissoring while a jar of mayonnaise is poured between them. You know, I mean, that's God telling you that it should be over. That's time for the end. And after that comment, I agree with him. I agree with him entirely. Let's see. Oh, shoot. I haven't activated Brave Rewards on my archive channel. Thank you for letting me know about that, Carlos. I will do that after the stream. Distract enemies tells me to take away mod from Lost in the Discord. I'd like to take away whatever is keeping him alive. Like, the Discord is one thing. But this man is still attached to the mortal coil, and that needs to end, I think. Check Discord general. Dabster? I really hate when people tell me to do that. Why? The Kermit the Frog Muppeteer was fired by Disney. Aww. Rude. Okay. So, anyway. So I only did one video today. I was going to do a couple because there's a lot to talk about. There's a lot going on. The Chauvin trial is starting to move a little bit. They're supposed to enter jury selection tomorrow. They have 3 weeks for jury selection. That's going to be a cluster and a half. There may also be, they're trying to get that third-degree murder fully added back. And then, of course, there's going to be the defense opposing that. And so they may get a delay on the trial start from that issue. So we'll have to just see what happens there. I do plan on covering the trial. I don't plan on covering much of the jury selection because that's like 3 weeks of jury questions. Doesn't seem like that would be the most interesting thing. But once the trial's in full force, if it's possible to live stream some of it, we'll do that. And, that'll just be up to what's available for us to cover. But I'll be keeping a close eye on the Chauvin trial. My predictions are that they don't stick him with a murder charge at all. You'll note I have said over and over and over again that the most appropriate murder charge for Chauvin, in my opinion, is third degree, because I don't see any way they stick a second degree. I think they could possibly stick a third degree. I don't think they actually will stick a third degree murder charge on him. I think they're going to stick a second degree manslaughter charge on him. I think that charge is likely to go with him. I think that's likely to happen, and we'll see. We'll see. You know, I could be wrong on all of this. They could convict him for second degree murder. They could let him walk. I don't know what they're going to do. You never know once it goes to a jury, but my best guess prediction at this point is that they get that second degree murder charge. And at some point, we'll probably go through and start talking about rules of evidence and how hard it's going to be to get some of this stuff in. Because I know there's a whole lot about Floyd, you know, his criminal history, his arrest in 2019, all of those things that they would like to add in, but it's just really inconvenient that there are specific rules of evidence that prevent doing those sorts of things. And so, you know, it's not that easy to get that stuff in. So whether or not that'll be part of the trial is a whole other question. And we'll have to see. We'll just have to see. That's going to be decisions made by the judge, and those decisions are going to impact what a jury is considering and what jury instructions come out of it. And there's a whole lot of time left to go on that. So there may be some coverage of the Floyd case, or the Chauvin case. However, one thing that did definitely happen today that does merit covering, and there should be a video on this tomorrow. Justice Roberts shows why he's unfit to be in charge of the court. I mean, he is at this point, we have to just go ahead and acknowledge that Chief Justice Roberts is not fit to be the Chief Justice of the Supreme Court. He just isn't. I'm done with him. I'm tired of him. And I don't think he's making proper judgments. I don't think he's making reasonable conclusions. And the ruling that came out today solidified that. That being said, there's no real practical way to make him not the chief judge, but that's where we are. So what we're going to do is just talk about how he's trash whenever he does something stupid. And what he did today was very stupid. It involved a free speech case and a school, a college, and since by the time it got to the Supreme Court, the kid graduated, Robert's like, well, you know, it's moot now because he graduated, and so it's no big deal. I mean, it's not like it's going to happen again ever. I mean, this stuff happens every day, and he's like, well, it's not like this is repeatable, but it is repeatable. And so thank God it was an 8-1 decision, 8-1 over Roberts. He is terrible. Terrible. And I've been a Roberts apologist for years. I mean, I think that he's carefully, like, I don't always agree with him, but I thought that he was thoughtful and reasoned at times. And I think, again, I disagree with his Obamacare decision, but his opinion on it does some clever navigating. I don't think the Supreme Court is there to be clever, but to his credit, part of his decision was rather clever on it and stuff like that. But at the end of the day, it's not about being clever. It's about being right, and it's about getting the law right. And he is consistently getting it wrong. So hopefully, someday he'll step down from the court and someone useful can get in. Good, Sheila. Look deep into these pores. So that's up there. Also, Trump told the RNC to shove it and to stop appropriating his name and likeness without his permission. I think that's great. Trump has been pulling power play moves, showing who the Chad of the Republican Party is since the inauguration, I should say. And that's been big stuff. I mean, the fact that he waited to make any speech until CPAC was a power move. It was a power move. The fact that his CPAC speech was an hour and a half late a power move. The fact that his CPAC speech was the most interesting, most watched, and most banned part of CPAC entirely as a power move too. He is setting himself up as a kingmaker, and the king that he makes may be himself. We'll have to see on that one. That's a couple years away. Who the hell do you think you are to say Roberts is wrong? I'm a guy who gets to say Roberts is fucking wrong. I'm a jerk on YouTube. I can say whatever I want. And also Roberts is wrong. With some level of frequency that should be alarming. So, Trump telling the Republican National Convention that they're not allowed to use his name. Another power play move. Needs a little bit of coverage. Those are some of the videos that are going to come out tomorrow. If you didn't catch it, I did a longer video today, Kyle Rittenhouse, and it's going through count six of his charging document, which is a minor in possession of a firearm, and why he cannot be convicted of that charge. And frankly, outside of some very crazy evidence that we haven't seen yet and would probably have manifested by now, there's basically no way he can be charged on that. And under the statute, the people who provided him the firearm are also going to likely beat their charges so long as they don't plea. I didn't include that in the video, but there is a case where someone who was 17 was convicted as a minor in possession of a firearm. They're in possession of a 22. However, the reason they were convicted is because they pled guilty. I mean, that's the long and short of it. They pled guilty to being a minor in possession of a firearm. Now, the judge should have caught the exemption and said you can't plead guilty to this, but they didn't. So, and if you ever want to know why you should get a lawyer, especially if you're charged with, a crime like that or crime of violence or whatever, you should always at least consult with a lawyer, because there's very possibly something you don't know about the law, and they don't have any obligation to tell you. I mean, Kyle Rittenhouse's charging document doesn't list the full statute, obviously. It just has a summary of the statute, that he was under 18, that he's in possession of a firearm, and when and where he was in possession of it. That's all it says. It doesn't say, oh yeah, this only applies to rifles if they're short barrel rifles, and his wasn't short barrel, so this doesn't apply at all. That's not listed on the charging document. And that's why you need a lawyer to help out with that type of stuff, and why you don't cop a plea deal without knowing what you're pleading to and what your options are. So, who do I think is the worst SCOTUS judge in U.S. history? I mean, Ginsburg died, so she's not very good at being a judge. I don't know. There's a lot to go through there, and I don't have anywhere near the basis on historical justices to know what all their decisions were. That's a tough one. Justice Black, I think, who wrote Roe versus Wade, may have done more damage to America than any judge in the history of the world has done to any country ever. When you start looking at the real impacts of abortion in the way that we've done it, you're talking about wiping out what would now be a fifth of the U.S. population. It's devastating. They talk about stuff like Social Security costs and stuff like that. Not enough people entering the workforce. You're talking about having a smaller military. You're having a smaller overall economy. I mean, the United States would be what trying to remember the conversions, but basically 15 to 20% larger than it is now, in theory. And we would have a higher proportion of natural born citizens rather than naturalized immigrants or illegal aliens. We would have a higher proportion of people born here. Without abortion on demand, we may not have seen the same decline in minority families and communities that just happened to kind of coincide with that abortion decision. Like you want one of the most devastating decisions in the history of the United States for sure. It's Roe versus Wade. And it's an absolute tragedy, and it's one of the most celebrated in our history, and the people who celebrate it are baffling to me. Like I'm willing to entertain that there could be some sort of constitutional right to an abortion, but what we did through Roe versus Wade was a tragedy. An absolute tragedy. Radier says, have you seen the lawsuit where movie companies are trying to sue a VPN provider? Someone emailed it to me. I haven't read it yet. I think you emailed it to me. Someday when I've had enough liquor, I will just spend 3 hours trashing Roe versus Wade. But I don't know, man. I don't know. That's a lot of anger. So, okay. Ace of Spades says, oh, what I wouldn't do for some pig head. Give me that bacon top. Oh, give me that pork rind. Miss Piggy pork rind me me on my cough, my cock, my green cock. Oh, Miss Piggy. Oh. The asterisk says, since Dems can't ignore Trump, let Patton land at Calais. Running for Senate/Congress in 2022. Different exec ticket in 24. Let the perpetual freakout be prolonged. Bonus, more Little Marco speeches if gunning for Senate. I don't think Trump is going to run for the House or the House or Senate, but it would be funny, but I don't think he's going to do that. Franco Miranda says, did you see what Emmett Plant is doing to a Star Trek convention? Let's just say he may be on the hook for TI. Emmett Plant is one of the biggest pretendopotamuses that there is. Consistently bragging about all of his Star Trek connections. I think he wrote one fan fiction book or something like that. Like just an embarrassing level of participation to claim that he is a Star Trek writer as he does is something that that deserves some mockery. But yes, I've seen his tweet. I guess I could pull it up here. Let's pull it up, take a look at it. God, you know what? I don't want to even look at this because there is so much sadness in this little manlet. Ugh. It's so pathetic. What? That's not the right, hold on. Nope. Where is my, oh, sorry, for some reason my screens got screwed up. There is not what I want. Not what I want either. What the flip? There we go. This one will work, sort of. Sometimes I wonder if my kids just come into my office and ruin everything. Here we go. All right. So, briefly, here's Emmett Plant. This thing all messed up? Yeah, this is still. There we are. All right. Really, Creation Ent? Vic Mignogna is a confirmed guest for your Las Vegas Star Trek con? Okay, please stand by while I contact everyone I know on the franchise and every fan I know on Twitter and inform them of your unbelievably stupid decision. We are Starfleet Star Trek. Okay. All right. I think I'm blocked by this soy-filled thing. Let me see if I can pull it up. I've got the archive open now, but let me see if I can pull it up and see how this tweet's doing. Oh, it's up to 100 likes. Woo! Dear Creation Ent, this would be a fantastic thread to share your cancellation and refund policies. Well, that cements I will not be attending. You weren't going to go, and neither were you. Nobody cares about you guys. I'm out. Been a while since I heard any Vic shenanigans. That doesn't say anything. Now, see, here's the great thing. Since Emmett has blocked everybody who disagrees with him, you're only going to notice comments basically reinforcing Emmett's decision here, because he blocks everybody who doesn't like him. If they follow through on it, his panel won't go well. I guarantee you his panel will go just fine. Like every panel and every appearance he's done, it'll be great. A lot of people are going to come see him. A lot of people are going to come say hi. The con's going to get hundreds more people than they would have. And that's just because that's what Vic brings to every single show. Every single one he does. He brings a bunch of people. He brings a bunch of energy. And he does a good panel. And the overwhelming majority of people who go there don't even really know or care about his situation. A guest already backed out. Okay. I wonder if that con has any idea. Is it still a mystery to them? Like, is that what we're suggesting? That the convention didn't know at this point? Let's see. Oh my gosh. So someone just sent me this too. Let's take a quick look at this. I know this isn't on the topic that we were on, but we'll get back to that in just a second. Since someone brought it up, let's take a peek at this. You could just, if you squeezed Emmett out over a pile of rice, you'd have fried rice with a nice salty balance to it. Okay. Kiwi Farms doesn't like zooming in. All right, so Emmett considered quitting his day job to put in overtime on Kick Vic. Claims he will do their Star Trek convention for free if they get rid of Vic. Again, Emmett, no one wants you there. You would. This is actually my favorite thing. I'll do it for free. You weren't gonna do it in the first place. We didn't invite you. And if we did invite you, we wouldn't pay you. Because literally, who are you? Like you literal who? Let's see this. Hold on. So here we go. Emmett Plant has an IMDb page. Let's just take a look at how much they definitely want Emmett Plant. Here it is. Emmett Plant at their convention. Because, I mean, that's important to know, is like what they're losing out on, right? Emmett Plant is a composer and director. Ooh, sounds very fancy. Known for The Binary Snow Job, A History of Cinematic Computers That Never Were, Caravel Drod 1.5, and Fruit Frolic. Okay. What? Huh? Who? I mean, I don't know why you guys don't understand why this highly in-demand Star Trek personality is not already on the guest list. But, you know, they could have him and he'd do it for free if they, you know, if they're just willing to get rid of Vic. Let's read this real quick. Considering taking a leave of absence to handle Creation and inviting Vic Mignogna to their Star Trek convention in Las Vegas. There's a lot to coordinate and a lot of conversations to have. If it requires my full-time attention, so be it. Emmett, stop pretending you're important. Stop. Nobody believes that you're doing anything during any given day. No, we can see your Twitter account. Nobody's convinced that you're doing work. Here's some contact information for Creation. Please consider retweeting this tweet. I imagine a lot of people have very good questions regarding why Vic Mignogna has been invited as a guest. No, there's one simple answer. He brings the bacon, baby. He brings the bacon. FYI, here's a link to my question for Creation Ent on their Facebook page. Please consider leaving a comment if you're also wondering why they have invited Vic Mignogna to their Star Trek convention in Las Vegas. By the way, you know, it might, I don't know. I don't know if it would be a nice thing to do to go and just say to Creation Ent, hey, thanks for bringing Vic. Really looking forward to it. I'm not suggesting anybody go argue with Emmett. I have a feeling you'll have a problem even finding his stupid comment because it's probably buried. But that being said, if you're a fan of Vic, if you're a fan of Star Trek, and you know anything about Creation, and I don't know anything about this, but popping by there and just say, hey, thanks for bringing Vic. Really love to see, you know, the fan community at Star Trek getting some love. Something like that. That'd be a great thing right there. Like, again, it's not about arguing with these people. Arguing with these people is pointless. Look at what they do during the day. This is what their life actually is. So don't sit and like respond and argue to this guy. This guy's an idiot. Another thing, I'll do your Trek Las Vegas convention for free. If you toss Vic Mignogna from the guest list, you get to toss a creepy dude with toxic fans or replace him with someone who actually worked on Star Trek. Where? Where did you work on it? Another thing, if Vic Mignogna remains on the guest list, please make sure you're running mics during his panel. I've got years worth of absolutely devastating content for the Q&A portion. I promise you won't want to miss it. Just got news of the first guest to pull out of Creation Ent's Las Vegas Star Trek convention due to Vic Mignogna's appearance. I won't release the name, but I'm very proud they're doing the right thing. You're not that proud. You won't release the name. Fake. Why you always lying? But anyway, this is the sad state. This is the sad state of people who are opposed to Vic. By the way, Emmett was never opposed to Vic. No. He was just telling his truth. He was never opposed to Vic. He never wanted anything bad for the guy ever. Emmett's been a liar from the very first moment of this. He lied to everybody, and he lies about his participation on Star Trek. He lies about his importance. He lies about literally everything. But, you know, that's what he does. But yeah, so anyway, thanks for bringing that up. That sad sack of garbage is still alive somehow. With that bitchin' it IMDb page. Lots of accomplishment to go around. By the way, I have an IMDb page, which is great. It was pretty funny when Lady Racket saw me on the IMDb page. She's like, "What the hell are you doing?" Look at this. What? A writer, director, producer. We got some writing credits. We got director, Lost Blaming the Interwebs, me showing up on Midwesterly, Heel vs. Babyface, Friday Night Tights, my own show, Jawbreakers and Dreammakers. I don't even know what this is. The Kill Stream and the official podcast, which I was on the official podcast, by the way. Long time ago. They were nice. I would talk to them again. But what is this? Me and Ty Beard. We must have had some show called Jawbreakers and Dreammakers. I don't even know what this is about. Hey, catch you later, Ken. Okay, anyway. That's enough fun for one day. Now let's get on to the serious topic. Here we go. No more fun for today. Now we're on to serious law business. Super serious. Let's see. Snuggle Struggle says Biden's dog bit a guard at the White House. Biden's dog has an awful Twitter page pleading the dog's innocence. Could you bring up the Smith-Mundt Modernization Act of 2012 one day and point to the propaganda coming from the White House today? Yeah, not today, but sure. Sure, someday. I don't know. Maybe. Okay. All right, here we go. Let's see. On to Joshua Moon versus Melinda Scott. By the way, when we get done today, guys, we're going to watch a movie over on Twitch. The movie, I think we're going to watch Rat Race. I hope you've seen Rat Race. If you haven't seen Rat Race, come watch it. If you have seen it, come watch it again. It's a good one. You might not remember it, but it's funny. That being said, also make sure to go and sign up to my locals page. You don't have to pay anything yet. It's still in beta. It's coming out, but once it fully launches, you want to make sure you're already over there. I did release a test upload preview video on locals. One of the cool things is that YouTube won't let me preview a Premiere video because they won't let you open the Premiere up for previews, which is stupid. But I can upload it to locals and preview it over there because they actually host video content over on the site. I did it today. It worked. It was cool. There will be, again, more content coming to locals and exclusive content. However, if you're currently subscribed on Patreon, Subscribestar, somewhere like that, I will be offering promo codes for easy switching over to locals and, to make it free for a month and all of that stuff. That's coming. So if you don't want to support over on locals yet, just go click follow. You don't have to support yet. Just click follow and make sure you're already following and and able to see it and stuff, and you've got it going. But once it's fully launched, there will be promo codes and everything for people. I just have to get all this stuff set up. So, that being said, should we jump into this? Let's jump into this document. Here we go. So, last we left off in this saga, the judge has vacated the default judgment. So, no default judgment. Joshua Moon has no longer lost the case. The judge is now at the point of considering the motion to dismiss, which he took under advisement, and he also gave Melinda Scott 14 days to file a response to the motion to dismiss. She has since responded. We covered that just the other day. However, along with her response, she filed a frivolous motion to have the judge recuse himself. She'd already asked the judge to recuse himself, and now she was asking yet again for the judge to recuse himself because he's not ruling the way she wants. Therefore, the judge hates women. That is what she is alleging. So, now this is the opposition to the motion to recuse, and it's about 4 pages. And then there's a letter from Melinda Scott to Josh's lawyer attached to this thing. And so we're going to read that too. So now comes Joshua Moon, lucky, by counsel and opposes the plaintiff's second motion to recuse. In opposition, defendant Moon states as follows. Ms. Scott cites only a series of unfavorable rulings as grounds for recusal. She makes no showing that such unfavorable rulings flow from bias rather than from the meritless nature of her legal claims and arguments. As the U.S. Supreme Court has made clear, judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. Binding precedent from the Fourth Circuit also forecloses Ms. Scott's arguments. Quote, if we were to encourage strategic moves by a disgruntled party to remove a judge whose rulings the party dislikes, we would make litigation even more time-consuming and costly than it is and do lasting damage to the independence and impartiality of the judiciary. In other words, recusal decisions reflect not only the need to secure public confidence through proceedings that appear impartial, but also the need to prevent parties from too easily obtaining the disqualification of a judge, thereby potentially manipulating the system for strategic purposes, perhaps to obtain a judge more to their liking. They have a footnote here. Defendant Moon has pointed out in previous filings that Ms. Scott appears to be needlessly escalating the cost and duration of this litigation. Mr. Moon's concerns in this regard largely echo those of the Fourth Circuit in Bellew, because Ms. Scott's meritless motions make litigation even more time-consuming and costly than it is. And yes, Josh having to respond to every single motion she files is getting a little ridiculous, but he does have to respond unless the court, sua sponte, comes in and says no prior to his response. But the court isn't watching this case that closely. They're busy. Indeed, unsupported and meritless attempts by a litigant to seek recusal not only threaten limitless gamesmanship, but the fearless administration of justice itself. The plaintiff's latest filing containing cavalier accusations of bias and sexual discrimination is but the most recent display of her escalating pattern of abuse of this court's processes. Ms. Scott's filings at docket numbers 15, 18, 29, and 41. See also defense filings. Oh, so they're citing her filings. Sorry. Ms. Scott first levied accusations of sexism and misogyny against the defendants in this case in her complaint. Plaintiff then levied such accusations against the presiding judge. That's motion to recuse docket number 15. She next accused undersigned counsel and defendant Moon of sexism and misogyny in correspondence dated January 8th. See Exhibit A. We're going to read that in just a minute. Including allegations that the plaintiff is a victim of sexism due to her handwriting style and the size of her forehead. What? Not gonna lie, I skimmed this earlier. I missed that entirely. Oh my God. In light of the plaintiff's behavior in this case, The fable of the boy who cried wolf comes to mind. This court might wonder if it is dealing with a pro se plaintiff acting in good faith, or if it is instead dealing with an unruly child not used to not getting her way. In light of the plaintiff's pattern of behavior throughout this litigation, it is disappointing but unsurprising that she has renewed her earlier accusations of impropriety directed at the court. Because Ms. Scott cannot demonstrate bias within the meaning of Canon 3 of the Code of Conduct for U.S. Judges, however, or bias within the framework set forth in Consolidation Coal Company v. Williams, her latest motion must be denied. So we ask for it to be denied. There you go. Now, let's take a look at Melinda's stupid letter. So, Josh's lawyer must have sent a sanctions letter to Melinda, informing them of their intent to pursue sanctions against her. All right. So this is her response via a letter. Mr. Harden, Esquire. As stated in my email on 1/6/21, I am in receipt of your sanctions letter and will respond here in writing. I will use this letter to highlight the inaccuracies in your letter regarding your asserted facts. I will go into detail regarding this case and others to demonstrate the factual basis for and merits of my filings. I will also use this letter to highlight the actual and real facts surrounding my filings. The actual and real facts show the situation here does not warrant the use of pre-filing injunctions and sanctions against me. So this is actually a nice intro paragraph. That's exactly what she's going to do. And now she's writing the rules. So she's doing better here. Virginia Code has no vexatious litigant clause in its laws. Virginia Code section 8.01 to 271.1 mirrors Federal Rule 11 and gives courts discretion to declare someone a vexatious litigant. Under section D of the code as a form of I wonder what she copied and pasted this from. This seems like a copy-pasted section from Melinda. I'm willing to bet that she lifted this directly out of something. But I don't know. Wonder if I have a tool to look for that. Because this looks like the sanction of declaring someone vexatious has been used very sparingly in the history of Virginia. It has also been used sparingly in the Supreme Court of the U.S. and in the Fourth Circuit. It is used most often in extreme cases, such as one person who filed 750 cases in 14 years, or another who refiled a case that was dismissed with prejudice several times, or one individual who filed more than 100 motions and requests for relief in one case that the judges described as imaginative, or a woman who filed 200 civil complaints in 3 years. The circumstances in cases where people have been declared a vexatious litigant do not match mine. The idea that I should be declared a vexatious litigant is simply your opinion. Well, that's just like your opinion, man. Or whatever. Either way, the court cannot ultimately ban me from filing, as my 14th Amendment right to due process and access to the courts cannot be barred. An injunction must not, however, effectively deny access to the courts. No, it just puts a burden on you to make a prima facie showing before the other party is burdened by your ridiculousness. Make no mistake, I am fully aware of my rights. Several of your motions and communications have been an attempt to try to intimidate and scare me out of asserting my rights. On their face, they appear like legal gaslighting, an attempt to make me think one thing is going on when in reality there is another truth. You want me to believe that I cannot bring a separate claim for a new cause of action when in reality I can. You seem to be trying to see just how knowledgeable I am. No, trust me, he's not interested in just how knowledgeable you are. He's not playing games here, Melinda. That's you. You're the one playing games. Everybody else is just trying to get this ridiculous thing out of court because it doesn't belong there. And if I am brave enough to assert my rights, I notice these aggressive attempts at silencing me often come after my push for discovery. This makes it appear to me that your client and others are desperate to hide information and have something to gain from hiding it. Your motions have also been used to harass me with derogatory insults, but the purpose of this letter is not to discuss that aspect. Then why'd you bring it up? Why'd you bring that up? My former cases against Joshua Moon were for appropriation, the tort of defamation, the torts of public and private facts, publication of private facts, and false negative light, and a Fourth Amendment violation as a state actor. Joshua Moon is not a state actor. Wait, no, he is. Moon's a Fed. We now know. Melinda knew. That's it. Melinda's just got a Fed sniffer. Probably one of her 9 husbands was a Fed, and now she can sniff them out automatically. The state appropriation case was filed in May 2017 in a state court. My only concern at that time was the effect my name and photo being on kiwifarms.net would have upon my small business. In fact, that is how I discovered kiwifarms.net. I did a Google search to check up on my small business. At the time, I had a website running to try and make sales on retail products I sold. Tried to make sales on products you sold? Okay. All right. The first case, a state case for appropriation, was for actions done by Mr. Moon in 2017. It was appealed in a state court in 2017 and ruled on in December 2017. The judge dismissed the case without prejudice. The judge only dismissed the case because everything I told him in the hearing did not actually appear in the complaint. As a side note, when I finished the case, I overheard the clerk tell the judge she did a really good job. Yeah, Melinda, bang up job. You lost. It was dismissed. You didn't do it. You did a good job, though. This lady is cray-cray. Snuggle Struggle says, my apologies. I didn't mean today as in switch your schedule for me. I didn't think you did. I meant towards the current use of social media by Biden's team. Anyway, Jawbreakers is Meyer's comic book series. Love the show. Keep doing you. Yes, it is. Oh, that's right. That's probably Jawbreakers and Dreammakers is probably something I did covering that case. There you go. Jeez. I heard the judge reply, yes, she did. That's like when you say, my 5-year-old walked into me today and said, Mom, the current jurisprudence surrounding Fourth Amendment procedure is absolutely inadequate and is an affront to our individual liberty. And everybody clapped, right? That's how this story sounds to me. He dismissed the case without prejudice to give me an opportunity to fix my complaint and refile. There's ample case law in Virginia to make Mr. Moon liable for using my name and photo without my permission as a for-profit business. Statute of limitations for that would be 20 years after me being deceased. Oh, yeah. The problem with it is you don't understand appropriation. Joshua Moon is not suggesting that the great name of Melinda Scott is endorsing the use of Kiwi Farms. So that's appropriation. Joshua Moon making fun of you on a website is not appropriation. That's a different thing, Melinda. That's why you lost. That's the real reason you lost, is because you didn't have a cause of action for appropriation. You're trying to gussy up something else by calling it appropriation. You're not the first person to think this would work, and you're certainly not the first person to lose this way. Countless plaintiffs have lost thinking they could do appropriation to get rid of negative commentary. Sorry, that's not appropriation. That's mockery. You merit mockery. You deserve mockery. Mockery is what belongs next to your name. You should marry Colin Mockery so that you get Melinda Mockery officially on a document. That would be good. That would be better. And maybe that's why you haven't refiled the appropriation claim. But that's why it was dismissed. While I contemplated refiling the case for appropriation in state court, the volume of content on kiwifarms.net grew and changed. I largely ignored the immature, vulgar, crass, and indecent comments made about me and my family for a while, until my child and I were physically assaulted by a neighbor and my personal property destroyed because of what neighbors read about me on kiwifarms.net. Another thing that likely never occurred. Peter Spinney, I only hate Colin Mockery as much as he hates himself. And after seeing that picture of him next to his child, whew, that's gotta be a lot. That's gotta be a lot. Because the volume of content on kiwifarms.net grew and changed and the increasing negative effects of the content manifested, I then filed 2 cases against Mr. Moon in federal court in 2018 for actions done in 2017, 2018. So this lady's trying to tell us that her neighbors, out of the blue, went on Kiwi Farms and were like, oh, this bitch's yard has to get trashed or whatever happened. Like that's what we're supposed to believe? That her neighbors, random people, were just suddenly on Kiwi Farms reading about Melinda Scott and were like, man, she's got to go. We're going to go destroy her property. Look, I've met a lot of people in my life, and none of them know what Kiwi Farms is, except for people I've met through this show specifically. And typically it's only after I have talked about Kiwi Farms, unless they're from Kiwi Farms. I met a couple farmers, humble Kiwi farmers in my travels. I've met them, but generally speaking, most people have no idea what this website is. Instead of refiling in state court, the appropriations case from state court was merged/transferred into a case with the torts in federal court. Judge Jones dismissed those for the reasons stated in his opinions. No case was filed before July 8th, 2020 for Mr. Moon's actions in 2019. Gee, why would he dismiss those? Oh, he said they were completely meritless. That's right. This case here before us is an IIED case. The IIED case, that's intentional infliction of emotional damage, before us is not, or distress, sorry, emotional distress. The IIED case before us is not a claim of defamation, nor of publication of private facts, nor of false/negative light, nor of appropriation. I mean, but it's based on defamation. That's your underlying claim, is that the IIED is based on lies about you. You don't get to just pretend that you didn't, you don't just get to pretend that it's not defamation if you're suing for defamation by calling it something else. Courts aren't that dumb. Case here was filed on July 8th, 2020. It is for actions done by Mr. Moon between July 9th, 2018, July 8th, 2020. Specific details from 2018 and 2019 may have been included, but that is not barred because the 2 former cases were both dismissed without prejudice. See, here she goes defeating her argument. She's saying it's not about those other cases, but then she's saying it is about those other cases. Under 28 USC 1915 E2B2, I went and looked up Judge Jones's orders today to double check, and yes, they were dismissed without prejudice. I know what without prejudice means. It means I can refile and bring the issue up again. Should I perfect my claim in writing and refile with more details and facts that I may have previously missed. So even if I won't include in this 2020 case elements, facts, and details included in my 2018 cases that were dismissed, I'm well within my rights to do so. Actually, I think you're beyond the statute of limitations, so I don't think you are within your rights to do so, Melinda. Because they were dismissed without prejudice. Therefore, it wouldn't matter if this case was based upon the same course of conduct, an objection you raised in your first paragraph. 1. I have never claimed to be a legal expert. Oh, no one has ever claimed you as a legal expert. I am actually a law school dropout. Law school dropout. Go back to high school. I attended law school with a merit-based scholarship at Appalachian School of Law briefly in the fall of 2017. This was after some of my cases were filed. Woo! I worked for an attorney for 6 months in 2004 while a freshman in college. I have a bachelor's degree, but I do not have a JD. I have filed and successfully prevailed in a few cases in state court between 2011 and 2019. I have mentioned these state cases in some of my filings. I have legal knowledge, but I have had a huge learning curve attempting to represent myself in federal courts. All of my filings have legal merits. I have simply made technical errors along the way that have gotten my federal cases dismissed. Just those dang technicalities, like not actually having a cognizable cause of action. A few of my cases had no case law upon which I could rely. Dang it. That's one of those technical errors. I simply had to break new ground in bringing the issue before a judge. For example, I sued a Mr. Carlson of Schenectady, New York, for using my business logo in a YouTube video which I alleged was copyright infringement. The Fourth Circuit had no case law upon which I could rely for this issue to consider using business logos as copyright-protected art. I don't believe that for a second. I do not believe that there is not a case law, or that there is not a case in the Fourth Circuit about using business logos as copyright protected art. It gave the court an opportunity to set a precedent. Not at the district court level. My case ended up being used as a precedent for another case. Oh God, what case? Here we go. I'm going to tangent on this. So it's a district court decision. Let's see. Let me get Virginia in here. So we've got Hawkins v. Fishbeck. Here we go. Take a look at this. Here we go. Let's see. We've got where did we go? I just had it. Oh, here we go. Scott versus Carlson. Right here. Quote, so, plaintiff's claim for copyright infringement fails because neither the plaintiff nor builder-fish entities have a copyright that can be infringed. Copyright Act is clear that no civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. So, citing Scott versus Carlson here, the registration requirement is an element of a cause of action for infringement that must be pleaded and proved by the plaintiff. I mean, I don't know that they necessarily needed this, but I'm going to take a detour. I want to read her case. I don't think it's going to be that long. It's 4 pages. So let's take a look at this. If that's okay with you guys. And if it's not okay with you guys, we're going to do it anyway. Let's see how Melinda did. The plaintiff in this case, proceeding pro se, seeks injunctive relief and damages for copyright infringement. Because she has not satisfied the pre-registration requirement for an infringement suit, I will grant the defendant's motion to dismiss and deny the plaintiff's motion for summary judgment and motion to strike. Ouch. Oh. Okay. Plaintiff claims that the defendant is distributing videos that belong to the plaintiff's business without her consent, and that the defendant is distributing videos containing the logo of the plaintiff's company. She asks the court to order the defendant to remove all of her videos from YouTube, the internet video sharing service, and to prohibit him from distributing any written material that belongs to her or her business. She seeks damages in the amount of $750 per video per day that it was published, as well as damages for any additional copyright infringements occurring between the date her complaint was filed and a future hearing in this case. The plaintiff has moved for summary judgment on the pleadings pursuant to Rule 12C and Rule 56. The defendant has filed a motion to dismiss. The motions have been fully briefed and are ripe for decision. The plaintiff also filed a motion to strike in response to the defendant's motion to dismiss. I will treat this motion as the plaintiff's brief in opposition to the motion to dismiss. Even back then, she was filing motions to strike the memoranda. Like, even back then, she was filing it this way. The Copyright Act grants a copyright owner the right to sue for infringement. A copyright infringement action thus arises under federal law for purposes of the Federal Question Jurisdiction Statute, and Congress also separately provided for federal jurisdiction over intellectual property cases. The purpose of a Rule 12b6 motion is to test the sufficiency of a complaint. A motion to dismiss does not resolve contests surrounding the facts, the merits of the claim, or the applicability of defenses. In ruling on a motion to dismiss, the court must regard as true all of the factual allegations contained in the complaint and must view those facts in light most favorable to the plaintiff. Where the plaintiff is proceeding without a lawyer, the court has an obligation to construe the complaint liberally. The defendant argues, among other things, that the complaint must be dismissed because the plaintiff did not register her copyrights as required to recover statutory damages under 17 U.S.C. 412. The plaintiff responds that whether she pre-registered her work is irrelevant because she is seeking statutory damages under 17 U.S.C. 504 and 501. She asserts that she is entitled to relief under 17 U.S.C. 106A and 412. The Copyright Act generally provides that no civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. The Supreme Court held in 2010 that this registration requirement is a precondition to filing a claim that does not restrict a federal court's subject matter jurisdiction. Nevertheless, the registration requirement is an element of a cause of action for infringement that must be pleaded and proved by the plaintiff. Now, again, like, that's where they quoted her, and she says that her case was used as precedent. I mean, kind of, except they're also quoting that from other cases because this is well established. Melinda is far overselling the importance of her case here. But okay. Of course, these are from outside of the jurisdiction, 11th Circuit and 1st Circuit. There is no exception to the pre-registration requirement for infringement suits seeking statutory damages under 17 U.S.C. 504. That section of the Copyright Act simply sets forth the damages to which a successful plaintiff may be entitled. Section 501 explicitly states that a copyright owner's right to relief is subject to the requirements of Section 411, which requires registration. The plaintiff's reliance on 17 U.S.C. 106A does not save her complaint. Section 411 does include an exception to the pre-registration requirement for actions brought under 106A. That subsection addresses works of visual art. As the defendant correctly notes, however, the Copyright Act explicitly excludes a motion picture or other audiovisual work from the definition of a work of visual art. The plaintiff's videos are thus subject to the general rule requiring registration of copyrighted works as a prerequisite to filing suit for infringement. Because the complaint does not allege that the plaintiff registered the videos at issue, it fails to state a claim upon which relief can be granted. The plaintiff contends that the company logo displayed on the video is a work of visual art under 106A that is exempt from the registration requirement. Section 106A, known as the Visual Arts Rights Act, applies only to very narrow subset of copyrightable works, namely paintings, drawings, prints, sculptures, and still photographic images produced for exhibition purposes. Discussing legislative history of VARA. Under VARA, drawings and paintings are protected, but only if they do not advertise or promote. The statutory definition of a work of visual art expressly excludes any merchandising item or advertising, promotional, descriptive, covering, or packaging material or container. I find that the term work of visual art, as used in 106A, does not include a company logo. Finding that an item which was a distinctive symbol of the owner's business did not qualify as a work of visual art. Therefore, the plaintiff cannot avail herself of this exception to the registration requirement for works of visual art. There you go. For the foregoing reasons, it is ordered that the motion to dismiss is granted, motion to strike is denied, and the motion for summary judgment is denied. Separate final order dismissing the case will be entered herewith. So there we go. That is what happened in Melinda's case that she is citing right now as precedent. It gave the court an opportunity to set a precedent. Oh, it was very nice of you. Except it was district court, not appellate court. So, some of my other cases have also been the subject of legal news. For example, a website concerned with religious liberties discussed my case against VADMAS. I'm not going to read that case, but notice the headline of the article here. 11th Amendment dismissal avoids ruling. So, yes, I'm going to guess that Melinda Scott sued and under the 11th Amendment was precluded from suing, and the case was dismissed. Good job, Melinda. Although you contend that I am embarrassed about my dismissals, I actually am not. You should be. I believe in using the courts, not violence, to protest the violation of one's general and constitutional rights. Even if technical errors, they're not technical errors, Melinda, result in the dismissal of a case, it is worth the effort of trying because the approach is dignified. It's not dignified. You're not dignified in this. You're not making cogent arguments. You're not bringing meritorious claims. You're just abusing. You're abusing people. You're terrible. My cases against Wise County Department of Social Services have nothing to do with punishing anyone. They did, as a matter of fact, violate my constitutional rights. Well, all those cases were dismissed. This is why their only defense was seeking 11th Amendment immunity. If you just sued them properly, 11th Amendment immunity wouldn't apply. They couldn't deny what they did. Nevertheless, I was surprised that they were awarded 11th Amendment immunity when I made a strong case that they were their own local governing body. Virginia actually has no definition of what a local governing body is under any Virginia Code section of definitions. Neither is the term local governing body defined by a Fourth Circuit case law. I looked. It is up to the discretion of the court. I believe in my heart of hearts with good faith that Wise County Department of Social Services should have been held accountable as a local governing body. The Department of Social Services is not a governing body. It's a subset of a governing body. The Wise County Board of Supervisors does not list Wise County Department of Social Services under their government structure. You can take a look yourself. The judge decided not to recognize Wise County Department of Social Services as their own local governing body, and that was at his discretion. Now the judge decided, matter settled. You've also failed to realize that the Fourth Circuit is lagging behind other circuits when it comes to constitutional violations by child welfare agencies. Many states actually have written into their laws constitutional protections for caretakers by requiring child welfare agencies to show up with warrants. My lawsuit against Wise County is breaking fresh ground. Other than it, but it didn't. You got dismissed. It's not breaking any ground. You got dismissed on 11th Amendment immunity. Other than the fact that the agency collectively was granted 11th Amendment immunity, there is no existing case law in the Fourth Circuit regulating these constitutional issues I brought up in my complaint. The only other option I have is suing individuals directly in their official capacities and suing government officials in Richmond, Virginia. Yes, which is what you should have done originally, because that's how you sue the government. Both of those present their own complications, but this letter is not the place to discuss those. Because you don't know what you're doing. Now I turn to your second paragraph. 2. Mr. Moon publicly presented himself as a transient person moving around from town to town. I know this from watching the things he posts online, as well as what his true and honest fans state online. Yes, true and honest fans. Hold on. Need more whiskey for this lady. Ugh. This would make personal service upon him at his place of abode problematic. Nope. Although I believe he has domicile in Florida that allows him to be a registered Republican on active status, Mr. Moon's mother's involvement in KiwiFarms.net would make service there problematic. Nope. I would doubt her willingness to forward the summons and complaint to Mr. Moon. Melinda, if he lives there and you leave it with any adult over 15, he's served, whether or not they forward it. If you serve him at an electronic mailbox that is registered to his business, he is not served ever. Ever. So if you just did what the rules said, it then is incumbent upon him to prove that he doesn't live there. I don't know why this is so hard. It's not hard. People serve people from prison, Melinda. Okay. I had the option of serving him as a business. You didn't serve him as a business. You served him in his individual capacity. And that is what I elected to do in order to meet the time deadlines required by federal rules. This lady is so stupid. She could have just simply amended everything and agreed to serve him. Said, "Oh, I'm sorry. I meant to sue him as a business. As Kiwi Farms. I would like to amend my pleading to include Kiwi Farms, to remove Mr. Moon as an individual, to serve him then under the rules for his business." But you didn't do that. In order to meet the time deadlines required by federal rules, just ask to amend it. In your third paragraph, you claim that I did not make inquiry into Mr. Moon's involvement into the affairs I described in my complaint. That is not correct. I also am aware that I am not legally obligated to disclose my exhibits to you at this time. I do not have to participate in interrogatories, requests for admission, and discovery requests from you unless the default is overturned. Oh, honey. This was, of course, sent before the ruling that the default was vacated, but should that time come, we can engage in an exchange of information of that nature. I'll also take the opportunity to say that making a malicious CPS call is a crime. The Virginia legislature has gone out of their way to remind the public that malicious CPS calls are not the purpose of child welfare agencies. Citizens of the Commonwealth of Virginia have several avenues in protecting themselves from malicious CPS calls. Likewise, reporting someone for owning a gun and fabricating false allegations like saying I said I would kill one of my children is something any reasonable person would act upon. I don't know any caretaker in the state of Virginia that would sit around idly in such a situation. You call the police. Whatever your motive is for expecting me to not speak up for or defend myself is irrelevant, but I will not sit down in silence. I am not a doormat, and I will exhaust every legal option I have for holding Mr. Moon accountable for his actions. He is not above the law, even though he has made several statements alluding to the idea that he thinks he is. In your fourth paragraph, 4, you claim that I have refiled despite dismissals. I've addressed this part in my statements above. I'm well within my legal rights to refile when cases have been dismissed without prejudice. That doesn't make me a vexatious litigant, just a persistent one. Every single one of my cases against Mr. Moon and others has been with merit, only not without technical errors. Guys, hold on. Oh, there it was. My neck was locking up. I have to just say this. We got to get this out there. Very rarely is a pro se litigant going to have their case dismissed on a mere technicality. They have to follow the rules, but judges construe things pretty liberally in their favor. That's part of it. Very rarely is it like, well, you know, your case is good. It's going fine. You got lots of merit here. But there was this technical thing you kind of missed. Oh, sorry. Click. Dismissed. No. That's not how the courts work. That's not even how it works with lawyers most of the time. Okay, sorry. Rule 11 expressly applies to pro se litigants, although the court may exercise sufficient discretion to take account of the special circumstances that often arise in pro se situations. Federal Rule of Civil Procedure Advisory Committee's note to 1983 amendment. Yeah. Yes. Rule 11 expressly applies to pro se litigants, but they give you a broad amount of leeway to screw up. In your fifth my point in this is that your errors aren't technical errors. It's not a technicality that's getting your cases dismissed. It's not having a case that's getting your case dismissed. Snuggle Struggle says Melinda is not a vexatious litigant. She's simply fortifying her filings. Yes. There you go. In your fifth paragraph, you allege that my litigation has been to harass, punish, cause unnecessary delay, or increased expense for Mr. Moon. Yes. That much is obvious. I deny each of those accusations against me. We have civil laws set in place, and when those are breached, our society has given people a way to right civil wrongs without violence. In the past, when people attacked another person's honor in society, people took to the streets and fields in sword combat. Duels prompted by attacking another's honor were common as late as the 1600s. They were common into the 1800s. Mr. Moon's website, kiwifarms.net, is bad journalism aimed at attacking others' public honor. It's not journalism, it's a discussion board aimed at discussing whatever people want to discuss. They just happen to want to talk about you. They want to discuss me. That must mean I'm disgusting, right? That's what it is, Melinda. You're disgusting, according to Eminem, the scholar. The targets of Kiwi Farms are specifically hand-picked to be people who defy their users' patriarchal, heterosexual, white supremacist worldview. Oh, you got called out, Kiwi Farm. You got called out. I am not saying this as a moral judgment upon their beliefs. That's why you put in patriarchal white supremacists. That's not a moral judgment, though. They have a right to believe what they want. What they do not have is a right to attack others in the ways that they do. Their motive is to attack me because I do not fit their patriarchal worldview of what a feminine female should be like. It's true. I have an abundance of proof demonstrating that. I have an abundance of proof to establish that Mr. Moon has actual malice towards me. You can even see the sexism in Mr. Moon's subtle comments. Sorry. When you add subtle in there, it makes it sound like sensual. It's like, as she read on, going through paragraph after paragraph of posts on the Kiwi Farms, she was drawn endlessly to Mr. Moon's magnetic prose. She could even see the sexism in Mr. Moon's subtle comments, calling her, enticing her to come closer, to read longer, to linger a bit more, drawing her in to his fiery rhetoric. Firstly, in the way Mr. Moon has attacked the quality of my handwriting, because in his mind, feminine females should have pretty handwriting, a common sexist belief in American USA society. You can see that in the way Mr. Moon has tried to put in a negative light my larger forehead because his sexist ideal is that women should have small foreheads. A common sexist belief in American society. Wait, are small foreheads? Is that... That's, you know what? Whenever I talk to all my patriarch friends, we sit around and we're like, God, you know what's wrong with women today? These damn foreheads are way too big. They gotta be those. We gotta get these broads some smaller foreheads. Know what I'm saying? That's the number one on the priority list of the Patriarch Club, of which I am a huge member. I'm a huge member of the Patriarch Club. Maybe a founder of it. I don't even remember anymore. But we're sitting around, we're like, these broads' foreheads be tripping. Be tripping men as they walk by because they're so giant. We got to shrink the size of foreheads. Forget about waistlines. Forget about increasing bust size. Forget about that shoulder to waist ratio. We're not concerned about any of that. What it is, the real patriarchy here is these giant ass foreheads. We don't want women to do squats. We don't want women to work off the jelly roll arms. We don't want women to be able to walk 35 feet without panting. We're concerned about the forehead, brother. Okay, sorry. You can see the patriarchal sexism in the dozens and dozens of comments about on Kiwi Farms about my life choices as a woman and my sexuality as a woman. Their unbridled defamation, hostility, threats, malice, lies, and social abuse aimed at me are because they do not want a woman with matriarchal elements in her family to have a place in this world. Their behavior is barbaric, extreme, outrageous, and indecent. It's like something out of the Dark Ages. While I do believe that many of the users are part of the countries that have not made as much progress as the United States in granting women equality, is still no excuse for their course of conduct, your client, Mr. Moon, included. I will not stand by idly and not speak up for my own gender in calling out their sexism and holding them accountable legally for their malicious, undignified attacks against me. Whoa. Woo! The nature of content on Kiwi Farms is not just fun humor. Them calling me Smelly Melly is simple humor. Oh, Smelly Melly. Not a big deal. But that is not... I can... Look, I have studied deep into the psychology of people being trolled online. I can promise you that Smelly Melly was more than not a big deal to Melinda. Actually, I would wager that Smelly Melly is included in this document specifically because it is one of the most grating things against her. Trump did this, by the way. Trump made a pithy 2-word marketing brand on a person. The most effective deconstruction of that person that exists. I've talked about this a lot of times. Low energy Jeb, that's 3, but you get it. You get it. An adjective followed by the name. Lion Ted. Little Marco, Little Ben Sass. You've got what is it? Slimy Mitch. You know what? Like all of these little things. Crooked Hillary. This pithy, Smelly Melly. I know that burns her up. Of course I know that burns her up because she put it in the document. The best part about legal filings in my opinion, by the way, is whenever they bring up insults, you can see what really got them. You can see what really pissed him off. That was one of the best days in the Maddox versus Dick Masterson lawsuit. Is Maddox sent 60 pages of abuse to the judge. He sent 60 pages and introduced it as evidence. And it was 60 pages of jokes. And you go, okay, here you go. Maddox has just given you a dictionary, a joke lexicon of the funniest things said about him that get to him the most. Because of course he did. They wouldn't pick ones that didn't bother them. It's not like they just went in order. Because you could tell they're pulling these things from different days, from different posts, from different topics, from different, podcast comment sections. And they're just going through and they're grabbing the ones that stick out to them. It's beautiful. Smelly Melly. But that is not the full scope of content on that website. Content on the website is an aggressive attack against each person they have targeted as a lolcow to socially abuse and injure them in any way they can. I was given journalism links by another person showing that many of the users on KiwiFarms.net came out of a movement called Iron March. Wait, is this real? Kiwi Farms, is this real? Is this real? What is Iron March? The Iron March movement was a white supremacist movement. They are known for their misogyny. What is this? Is this the deep lore on the Kiwi Farms? Is it a Nazi op? I am not the only lolcow that has been injured by their course of conduct. I am not the only lolcow, or person for that matter, that sees their conduct as indecent and inhumane. When someone attacks another person's public honor with the intent to injure, harass, or sabotage their well-being, there are legal actions that a person can take to resolve this issue. I am aware of my legal choices and have done nothing more than exercise those options, using the time and resources that I have. I have the right to hold Mr. Moon legally accountable for his actions, and that is what I have elected to do. You may have tried to forewarn me of monetary penalties in your belief that my complaint motions and filings are frivolous, but I simply don't agree with those beliefs. I think that you're trying to be a good lawyer to Mr. Moon by using every tool at your disposal. However, I still disagree with your legal conclusions. Your sixth paragraph are statements about costs incurred by Mr. Moon. As I mentioned before and am emboldened to reiterate now, Mr. Moon had the option of removing my name and photo from his website to have a 0% chance of risking litigation. That's not how that works, lady. If he has the right to have it on the website, you saying, look, I'll let you exercise your right for free, or I won't let you exercise your right, and then I'll try and make you pay. That's trying to bargain with poison. That's not a real thing. I am not punishing Mr. Moon with attorney's fees. Bruh. He simply is experiencing the consequences of his own actions. This right here. He simply is experiencing the consequences of his own actions. The judge should. This is not how the legal standard works. I'm not making a legal determination of what will happen. Nobody needs to run and say that Nick said that this will happen. This is not how it works. This is how it should be. A judge should read this sentence in the context of a frivolous case like this and go, that's a vexatious litigant. That person needs to be sanctioned for attorney's fees, and they need to be prevented from suing this person without demonstrating a prima facie showing prior to the other person being involved in the future. Right there, that sentence alone says everything you need to know about Melinda Scott. Attorney's fees, when you are not guilty of something are not the consequences of your actions. If I do something I am legally entitled to do and someone else sues me and I incur attorney's fees, that's not the consequence of my action. When I win and their case is dismissed, that's the consequence of their action, and they're a piece of shit. Melinda, you are a smelly piece of shit. Smelly Melly, for this. For that sentence alone. The fact that you don't understand that someone exercising their legal rights, even if you don't like it, and you employing and weaponizing the legal system against them, and then blaming them for your choice to frivolously file lawsuits, that's on you. That's not on them. And if I were a judge, and had my way, that would be the basis right there. I'd say that's sanctionable right there. This clearly demonstrates her intent to use the legal process to impose consequences outside of the court's legal remedies. That's not how that works. The court imposes a consequence. Hiring lawyers isn't a consequence. Ace of Spades says, and the Lord said, I shall create women in my image, and one trait that will make them feminine will be a small forehead, not their ample bosoms, or fat badonkadonks, or their thin waists. It is the foreheads, yes. Do you love it? Do you love him? Give me an amen. Give me an amen for Jesus and small foreheads. Yes, brothers. Okay, thank you, Ace of Spades, for that. All right. Additionally, Mr. Moon is getting substantial financial support from his users. This is another thing that is common in any case where crowdfunding or third-party funding happens. Where they're like, look, he's getting support. That support would otherwise go to anything else in the world than a legal fee. You're not convincing a judge by doing this, by the way. Judges know how expensive court is, and they don't like it. They don't actually like that. And Melinda, you've asked this judge to provide this to you for free. He knows that too. I hate this appeal. So on some level, he is not feeling the effects of paying for attorney's fees. Yes, he is. I don't care if Peter Thiel comes to your office and drops a check for $1 million and says, go sue this person. I'm paying for it. That's money that was otherwise destined for anything else. Maybe even for you. We don't know. But just because someone comes in and pays attorney's fees doesn't mean that they're not suffering the effects of it. There's a dignity hit in asking for attorney's fees and asking for support of any kind. Not a lot of people are comfortable doing it. Some people have gotten very good at it. Other people are master grifters at it. And then some people are like, I really hate asking for help from people because I've worked my whole life to not ask for help from anybody. And now I've got this big thing and I've got to ask people for help. That's still a cost. I hate people who do this argument. To avoid attorney's fees and litigation costs, Mr. Moon could have removed my name and photo. He could have changed the platform of his website to be less socially abusive. He doesn't have to. He has the right to do what he's doing. He could have reached out to me with an email discussing in a civilized manner my objections to the use of my name and photo. He has a lot of potential to be a good journalist. He's not a journalist. Joshua Moon is not a journalist, guys. But without ethics, one's talents are useless and a source of trouble. Melinda, this is one of those profound statements that should be said into the mirror. I've also seen in your motion that you are requesting for a pre-filing injunction. In, quote, in determining whether a pre-filing injunction is substantively warranted, a court must weigh all the relevant circumstances, including the party's history of litigation, in particular whether he has filed vexatious, harassing, or duplicative lawsuits. Literally, yes. Yes. Whether the party had a good faith basis for pursuing the litigation or simply intended to harass. Oh, I don't know. Consequences of your actions, right here. I mean, if I were writing Josh's motion for sanctions, I would specifically focus on this line. I'd just quote this paragraph and bold that line and these other lines down here. She's trying to extort him and force him to not do what he is legally able to do, well within his rights, and she's trying to do so using the cost of the courts. That's what she's trying to combat it with. The cost of the courts, knowing that she's going to lose because she loses all these cases. Every case. The extent of the burden on the courts and other parties resulting from the parties' filings. I mean, the crazy thing is, the court may not find it too burdensome that Josh has to pay like $15,000 for this. But most normal people will find that burdensome. It's not burdensome to Melinda at all. The state paid for it. And the adequacy of alternative sanctions. There's no alternative sanction for Melinda Scott. She actually posts this 4-part test, and it shows exactly why this sanction should be put upon her. She doesn't have any money, so there's no alternative sanction against Melinda Scott. The burden on the courts and Josh are far higher than on Melinda. But she's filing pro se, and she's filing in forma pauperis. So she's not paying jack for any of this. But Josh has to pay for every response, and the court has to deal with all of these frivolous filings. Whether the party had a good faith basis for pursuing the litigation or simply intended to harass, she's laid out here a nice case for harassment, in my opinion. And then the party's history of litigation, in particular, whether he's filed vexatious, harassing, or duplicative lawsuits. All of these lawsuits are duplicative, and they're all vexatious and harassing. And the way she conducts herself within the lawsuits, with motion after motion, with improperly titled things, making the same mistakes in the same ways across multiple lawsuits. I mean, I think she fills all 4 parts. I don't think the judge is going to buy it, but I think there's a good argument there. It's a non-frivolous motion to label her a vexatious litigant. The requirements of obtaining a pre-filing injunction do not apply to me. I think the opposite. My history of litigation at the state court level, which I can present exhibits if needed, is about a 70% success rate. 75, sorry. I had one case dismissed because I was 20 minutes late. I had another case dismissed because I didn't join in a second defendant and didn't have time to follow up. There are attorneys with average success rates as well. Even attorneys don't always get judgments in their favor. I can also demonstrate with exhibits before a judge if needed that my cases aren't frivolous, just an issue with technical errors. I'd be real curious to see those successes that she got. I haven't filed any duplicate lawsuits. I have a good faith basis for merits for each and every lawsuit I have filed, and I can demonstrate that to a judge if needed. My cases, it's not subjective. My cases haven't been a burden on the court. On one count, I would think a judge would be flattered by the opportunity to correct and demonstrate law to a law school dropout with an interest in law. No, that's why judges will volunteer to teach a semester at a law school. God. My cases have also set a precedent for other cases to the advantage of judges and society. Some of my cases have been cited in legal news as cases of interest. Government defendants haven't had any burden of cost because their attorney's fees are paid for by the taxes that I pay. You don't pay taxes, you lying cunny. You lying sack of garbage. You're too poor to pay anything. Everything is paid to you. You're a net burden on society. What are you the taxes that you pay? What, the sales tax that you occasionally pay? Sweetheart. The net sales tax you pay per year probably doesn't pay the first filing fee. If the judge had such an issue with my cases, I think they would not dismiss them without prejudice. They also could have barred me from filing sua sponte, but have chosen not to. That says a lot. Not as much as you think. Your client is interested in minimizing his attorney's fees and preventing further litigation. He's welcome to send me an offer of settlement in this case. There it is. Again, I would throw that along with that other paragraph about 6 in the motion for sanction. She thought she won. She thought she finally won on a technicality because that's the way she thinks she loses. But she doesn't lose on technicalities. She loses on reality. That rhymes, so it's true. Ugh. Gross. Okay, let's see. Let's get this other thing up. I don't want the chat replay. All right, so here's one case we've got. This is a thing by a lawyer. Let me get that up here. Did you guys see Meghan Markle and Harry? You see that? Meghan Markle complaining about learning the British national anthem because she married a literal prince. I don't know what's wrong with Harry besides that guy being an absolute turbo simp and an embarrassment to masculinity. God, can you imagine? I hope the Queen writes him a letter and that, and that when she dies, eventually that letter is released and it just says, "My God, Harry, you're such an insufferable cuck." So right before we get started, guys, today I was out. I got Lady Rackets a birthday present. I got her a birthday present. We went out and we bought a hot tub. And I'm calling it a birthday present for her, but really we know why the hot tub is purchased, right? We understand the real reason. The only sensible reason that that one would buy a hot tub in 2021 is because I plan on doing thought streams from the hot tub. Not for Kid 6. What kind of degenerates are you? This is about Twitch, ladies and gentlemen. This is about me being in a hot tub doing Twitch streams like a proper Twitch. I have seen exactly how you make it on Twitch, and it's a bikini in a hot tub. I am definitely everybody who said kid number 6. I mean, guys, hot tubs are not an ideal location for that sort of activity. It is not recommended. Not recommended. That doctors should come out and tell people, y'all, it is not comfortable. Stop. Stop it. Movies be lying to you. Socialism is for Fig says, did you see the giant ankle monitor on Oprah? She's probably been arrested for trafficking children. I did not see that. If you do the stream, I'm converting to Islam so I could follow the hadith. Throw the poof off the roof. We'll see. Hot tub streams. I'm gonna film a bunch of hot tub videos and just mail them to Spectre on like DVDs and stuff, written in Sharpie that say hello with an exclamation point. Mm. It does not depend on the hot tub. No hot tub is conducive to baby making. They're terrible, terrible instruments for that. So that being said, that was why I only did one video today, by the way. I was out with Lady Rackets. We were buying a hot tub. It was good times. I can't wait. We should have it in like a week or two, something like that. You can't order a hot tub right now. COVID killed that. If you wanted to order one, in our town, it's like a year. It's like a year out to order a hot tub. But they ordered a bunch of hot tubs before that are coming in now. And so you can go in and buy one that's in stock. That's what we had to do. But anyway. All right, let's do this. So here's the hearing, and we're going to find out something about an abusive boyfriend or something like that. I don't even know. Here we go.
Kind of both got really angry. It's just kind of like an accusative argument, just like, I don't know.
Mary, did the police come to your apartment that night?
They did, yeah.
And why did they come to the apartment?
Look, Deborah Davis, we've got to address this, chat. Deborah Davis over here. Her forehead is way too large to be conventionally attractive. The patriarchy needs to come and smash that forehead down into a reasonable size. This is ridiculous. What are we doing here? What are women devolving into that they got these giant foreheads walking around in public? Put a hijab on that thing. Oh my God. All right, sorry. Mega Mobas says, holy crap, I know some of these people. David Marvin is an interesting person. This is from my county. Oh, hey, Mega Mobas, tell me whatever you want to tell me. I'm curious. I'm curious.
Because the police were called, so they came here.
Who called the police?
Me?
I mean, technically me.
Okay. And
oh, this is a sad and frustrating reality of domestic issues, is that, someone will call the police, right? And then they'll have to realize like that they're going to go through a bunch of consequences for this. So like the police were called. That's a very passive statement. Who called the police? Technically me, like I did. Yeah. Now, this will become more obvious as to maybe why she's couching stuff in a minute, but pretty interesting. This is a sad reality of domestic abuse, by the way, is that, domestic abuse happens in the heat of the moment. One partner, and it's not always a woman, but one partner is, they feel scared, they're getting hit or whatever, and so they call the police, they invoke the authorities. By the time the police get there, the situation is de-escalated a lot of times. Obviously when it's really bad, someone gets beat up, that's one thing. If someone's been hit or threatened a lot, mostly with the threats, and then the situation calms down and de-escalates, well then, now you've got a weird issue where some time has passed, the police show up, everybody's okay, and the fight is over. And suddenly they're like, oh, shit. Now you got to deal with the fallout of having the police involved in your fight. That doesn't mean that these fights aren't abusive. They very well could be abusive. But this is one of the hard things as an attorney on domestic issues, is the fact that you get uncooperative witnesses because they realize, oh, I really don't want to go through this anymore. I've represented people on both sides of domestic violence, both perpetrators and victims, in various ways. I've represented both of them, and what I find a lot of times is outside of the heat of the moment, people kind of want it to go away. That's where they want to get rid of what happened. They want to move on. And sometimes it's a one-off incident, and other times it's a pattern. And the attorneys in the case you don't know if it's a pattern or a one-off. But what you do run into is hesitation and resistance and a lack of candor and honesty, typically on both sides, on perpetrators and on victims. No one wants to be honest during these things. It's very frustrating. I hate doing them.
When the officers arrived, what did you tell them had happened?
Objection, Your Honor. I think that's asking for hearsay. I think, wouldn't she ask what happened, not what she said that day? Because that would be hearsay, what she said that day. Because it's asking for her to repeat
Your Honor,
what she said out of court.
Okay, number one,
It's not hearsay. She's there. What did you say? What did you say to the officer? It's not hearsay. She's the person who said it.
Your Honor, I have reason to believe that the defendant is in the same apartment as the complaining witness right now, and I'm extremely scared for her safety. And the fact that she's looking off to the side and he's moving around, I want some confirmation that she is safe before we continue. And that wasn't hearsay. We'll get to that in a few moments.
Miss Lindsay, where are you right now?
Uh-oh.
I'm at a house.
What's the address?
It's my house.
What's the address?
108 West Hatch.
Okay. Mr. Harris, where are you?
703 East Lafayette, Your Honor.
All right, what are you on, a laptop or a phone?
Me?
Yes.
Phone.
All right, I want you to walk out to the front of the house, show me the house number on the house.
Uh-oh.
Why? I don't even think this phone has the charge for that, sir. I'm at like 2% right now.
Yeah.
I'm hooked up to this wall charger right here.
Your Honor.
We're knocking at the door right now for Miss Lindsay.
What?
The police are at Miss Lindsay's apartment right now, knocking on the door.
All right. Ms. Lindsay, would you go answer the door?
Yeah, give me 1 second.
You take your phone with you so that I know you're okay.
Okay.
Go ahead.
Colby's here.
Yeah.
If this man gets arrested on camera, I'm gonna die. Uh-oh. Uh-oh. Look at him looking off to the side. Play it cool, brother. Oh. Where'd you go? Why you
We may
running?
need to adjourn this, Your Honor.
So it appears Mr. Harris is there at that house.
I believe so, Your Honor. We would ask that his bond be canceled.
Yeah, so we'll confirm what we're gonna find here.
Officer Edgington, which officer have responded?
I was speaking with Sergeant Marsh.
Thank you.
Come on now. Oh wait. Why does he keep showing up?
He just hung up.
I hope they confirm this. Please confirm it. Edgington is edging me right now. I need to know what's happening. Just hang up, bro. The police won't arrest you. You know Paul Gibson is like, mother.
This is a issue we didn't have when we had live court. This is the first time, to my knowledge, if he is in the same venue, that this has occurred. Kudos to the Sturgis Police Department for following up on this. Let's see if someone can log in. Officer Edgington, do you have contact with Sergeant Marsh?
I can try to give him a call.
Yeah, would you please?
Your Honor.
Yes?
Mr. Middleton?
Yes.
Mr.
Who am I
Middleton?
speaking? Yes, who am I speaking with?
Kobe.
Yes?
Your Honor, me and Mary both don't want the no contact. I asked if that be dropped. I'm sorry I lied to you. I knew the cops were outside. I don't know why I lied to
Mr.
you.
Harris, my advice is don't say anything else. Take the cigarette out of your mouth. The hearing is adjourned.
He's on her phone.
Your bond is canceled.
Oh shit! You're going to
You have
jail
$10
now.
million you can't bond out. In addition, the prosecutor is probably also going to charge you with obstruction of justice. It may be a situation of you and Mary want the bond conditions lifted, you want them lifted. She does not. We're serious as a heart attack. It's the first time I ever had anybody sitting in the next room potentially
I
intimidating a
never
witness and
attacked her.
assault great bodily harm. All right, don't say any more about it. Your
Yeah,
bond
shut
is
up.
canceled. You're digging your hole. You've hit bottom and you're continuing to dig. Officers are directed to take him into custody on a bond violation. Bond is canceled. We will reschedule this hearing for another date. Ms. Lindsay, the prosecutor's office will be in contact with you to reschedule this. Mr. Gibson, I know that was all completely outside of your knowledge or consent.
Thank you.
And let's continue this for 2 weeks to my next duty week, which would be
Oh, don't say anything else. For the love of God, you're digging straight down and there's lava below you, you moron. And he shows up on her phone. That made it even funnier. Because he might have actually run out of battery. Like, that would be hilarious. Look, as he's getting handcuffed. Look, Mary, y'all, my phone's out. Can I talk to the judge on yours? What a dummy. Oh, God, that was good. That was good. That looks like, they said Sturgis. Is that in South Dakota? Like, is that Sturgis, South Dakota? Not, I mean, I know Sturgis is in South Dakota, but is that Sturgis, South Dakota that they're talking about? Oh, my God. My legal advice to that guy is not to do what you do. Look, here's the tough thing. If you have a bogus domestic, and they happen, bogus domestics occur because it's not always up to the victim whether or not they want a domestic charge. So if a cop comes in to, like, let's say two people are arguing and yelling, right? A neighbor calls, not one of the people involved. A neighbor calls, cop shows up. Someone's got an existing wound, a bruise, a cut, a scrape, something like that. Cop thinks it's related to domestic violence. It may be, it may not be, but let's hypothetically say it's not. Let's say they fell onto a doorknob or whatever, and that's why they have two black eyes. Okay. But legitimately, they have an injury that's from something else, but the cop says, this is an injury that looks consistent with other injuries I've seen from domestic violence. So they make an initial determination that there was domestic violence. Now, the prosecutor comes in, charges based on the cop's observations, and then they implement a no contact order in the criminal court. In Minnesota, they can do a no contact in the criminal court without the consent of the victim. They can do that. It could be bogus. Here's what you have to do in that situation. It sucks. It's bullshit. But you have to obey the court order. You have to obey the order. Especially when you're on the damn Zoom call with the court. Like, just go outside. Where are you? Oh, I'm just hanging out at a park. There's an outlet here. I'm at a bus stop. I'm at a grocery store. It doesn't matter where you are. You're not at their place. Obey the order. What the hell are you doing? It's in Michigan? Oh, okay. Oh, my God. Just go anywhere else. Just go anywhere else than that. Oh, that was fun, though. That was hilarious. For non-blonde says, well, I wake up in the morning and I step outside and I take a deep breath and I get real high and I say, what's going on? And I say, hey, what's going on, America? I used to like you. Damn. Four non-blondes coming in with a savage take. Socialism is for Fig says, Nick, isn't what they just did a constitutional violation by the court? Don't you have the right to privacy? You don't have the right to be in violation of a court order. So no. And you don't necessarily have any right to privacy on your location for a Zoom meeting with the court. That's a court appearance. And if the court orders you to appear, and there's a reasonable suspicion that you are appearing at a place where you're not legally allowed to be and someone notices, then they can go ahead and ask that question. Now, you didn't need to say anything, but it was going, like, they can't compel him to say, yes, he is. But they asked him, and rather than him saying, Your Honor, I'd rather not say, or Your Honor, I'm exercising my right to remain silent, and then turning off his phone and bolting out the damn window, rather than doing that, he chose to lie to the court about his location while being in violation of a protective order, or his bond arrangements. He doesn't have it. You do not have a constitutional right to do that. So, no, that wasn't a violation of his privacy. If they had just randomly asked him, actually, no, even in that case, he had no obligation to answer them. You can't be forced to offer incriminating statements against yourself. Oh, excuse me. So he could have just said, I'm going to choose not to answer. Oh, I've got I've probably got it up, click, and then run out the window. That's what I would have done. That would have been a beautiful, beautiful thing. All right, I'm bringing up the other court case we've got. I got to find it real quick. Yeah, that was funny and refreshing. That made me very happy. Where is? Here we go.
Have in the care, custody, and
All right, this one's a little bit longer. This will take us probably to the end of the show. Probably should fire his lawyer for not advising him not to answer the question. Yeah, what his lawyer should have done, again, have him go to the lawyer's office. Notice where Kyle Rittenhouse calls in from every time, his lawyer's office. Great plan. Good plan. Also, guys, I'm a couple whiskeys deep, but if you go ahead and get that thing up to 1,000 likes, I will, of course, drink another shot of whiskey just for you. Just for you. Okay, so this case is a CPS lawyer wants judge to allow social workers to lie. Now, when it says judge, I mean, these are 3 judges. This is an appellate court. This is an appellate court. Ash B says, anyone here super straight? Oh, bro, I am the superest straightest that there is. I would, sorry to all the trans ladies out there. I would only ever be interested in a biological female, period. No hate on you. You do what you're going to do. But as for me and my penis, it only likes biological women. So, all right, on to this claim. Or this video. Alanis Morissette says, if you have to sing, isn't it ironic for everyone now because you drank whiskey? It's on you now. You did this. Why would I have to sing, isn't it ironic? Does that include trans men? No, well, I mean, yeah, no, I'm not interested in a female presenting as a male either. That's not a thing. That's real to me. Okay, so here we go. Nick with some freaky stuff in Thailand. Do some freaky stuff in Thailand, guaranteed. No. Oh, we're over 1,000. Okay, I'm gonna start this hearing up because it takes a minute to get going, and then I'll pour the whiskey.
May I begin?
Yes.
Thank you, Your Honor. Good morning. May it please the court. My name is Pansy Lin, and I'm here today on behalf of appellants and defendants in the underlying matter, Marcy Vrikin, Elaine Wilkins, and Helen Drojak by and through her estate. If I could reserve 2 minutes for rebuttal. Thank you. The facts underlying this case are many and sordid, and I won't go through them all here.
Thank you.
Thank you, Your Honor. And
they're many and sordid. This is a Child Protective Services case, so the facts could be very, very ugly. But yeah, so she's not going to go through them all. She's going to stick to the legal argument. This is the appellate level. They don't really care about the facts. They care about the law. What is the law that we're trying to establish here?
But I will summarize that there was a divorce. The divorce was followed by a raging custody battle, which ultimately led us into juvenile dependency court, wherein in those proceedings, the custody of 2 daughters was ordered removed by the juvenile dependency court from their mother. These 2 daughters were Kendall and Presley Hardwick. Presley Hardwick is the plaintiff in the underlying action and the appellee here. Fundamentally, this appeal presents 2 issues, whether the individual defendants were entitled to qualified immunity for their actions and whether they were entitled to absolute immunity for their actions or for the actions that they are being sued for.
Are you seriously pressing absolute immunity? It wasn't pressed at all in the state. Are you?
That's your first bad sign right there. Are you seriously pressing this? If a judge tells you, are you seriously pressing this? 2 things happen, okay? First, you say, yes, Your Honor, I am. Second, on the inside, a little bit of you dies and you go, fuck me. Those are the 2 things that happens when a judge says, are you serious? because they're already pissed.
Are you serious about that, or are you going to waste time with it?
Oh, damn.
I am serious. Certainly would not bring an argument to this court that I'm not serious about. I am serious about the argument because there are fundamentally acts for which our defendants are being sued, these social workers are being sued, that I believe come squarely within absolute immunity. I understand that qualified immunity is the issue here for substantively the removal pursuant to the court order of
Why don't you go to
children.
qualified immunity?
Of course, Your Honor.
We have your briefs on absolute.
We have your briefs on absolute. We don't care. You're not winning on absolute immunity. He just told her. Just skip that. That was nice of him to do. Just save your breath.
Thank you, Your Honor. In terms of qualified immunity, as this court is aware, it's a two-prong analysis. The first being whether there is a constitutional rights violation that has been alleged, and the second prong being whether the constitutional right was clearly established such that our government actors know without doubt.
Look at bald penis-shaped man here. Like, look at his face. Like, he's almost got a Tucker Carlson face listening to this chick.
That what they are doing would be a violation of the law. The court is entitled to take these prongs in any order it perceives, and here, typically when we have the qualified immunity analysis and whether the law is clearly established, it is typically plaintiff's burden to come forward to this court and say, here is the case law. This is what tells the state actors, the government actors, that they should have known better. It's clearly set forth in this case law.
They all look pissed.
It's interesting because the reverse has actually happened. This court has actually found that as of the date of the underlying conduct here in 2000, when
You talk about Costanich?
that is correct, Your
Costanich
Honor.
deals with foster care licenses and guardians, not natural children of parents.
Costanich deals with the underlying liberty interest of a 14th Amendment claim, which is the same
For foster
For
parents,
foster
though.
parents.
That is true. A guardianship.
And guardianship, not natural parents. It seems to me that as early as the 1940s, the United States Supreme Court has held that there is an absolute liberty interest, a fundamental liberty interest that parents have in the care, custody, and control of their children. That's been on the books forever. I have a whole bunch of Supreme Court cases I can read from. That's just going to waste a lot of time. They have that fundamental constitutional right.
And this is when you know, like, your argument is in the gutter at this point. For foster parents and guardians. Not biological parents, not natural born parents. What are you doing here? What are you doing? It's great. By the way, she has an appropriate size forehead for the patriarchy, so that's good. No need to compress her forehead. Bill Clinton says, I did not have sexual relations with this woman, though I would if she's hotter than Monica and Hillary combined. Oh, God. Oh, Christ. If you combine Monica and Hillary, you'd have a singularity. It would collapse in upon itself. There would be folds for fucking days. Light could not escape. It would smell so awful. Okay. Back to this.
It
cannot be impaired without due process of law.
And where the qualified immunity analysis and the clearly established law plays into this is, do we have case law that tells us that?
No. You've read Help versus Pelter. There doesn't have to be case law. There can be other ways of showing that it's clearly established. Case law is not an absolute requirement.
It is.
Have you read?
You've read Help versus Pelter, right? That was the implied, right? You're not going to stand in front of my court and tell me you haven't read our decision in Help versus Pelter.
Hope versus Pelzer and all the other cases that talk about that?
Yes, Your Honor.
Okay, there does not have to be a case on all fours.
You're correct.
Correct.
There does not have to be a case on all fours.
Right. What isn't clearly established here?
The fact that what Costanich says, what's not been clearly established in the year 2000 when this removal occurred was the idea that the right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of a protected liberty interest.
Did you hear what she just said? We're going to go back and listen to this sentence again. And my God, if you're not burning the state to the ground, I mean...
What Cassandra says. What's not been clearly established in the year 2000 when this removal occurred was the idea that the right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of a protected liberty interest.
The right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of liberty to raise your own fucking children. That is what she's arguing right now. The right for CPS to intentionally lie to take your kids away. Look at the judge's face. Look at this guy. This guy has sunk into realms of anger and depression that could only be described with language from the warp. This guy's like, you fucking what?
Same liberty interest that's at issue.
But it's not the same liberty interest because this was a parental liberty interest.
It's a biological versus foster.
Let me just hold up for a second, though. This court is quibbling over whether or not it's biological versus foster. Bitch, I don't care. As a foster parent, you should have an absolute immunity, an absolute right to be free from an intentional, deliberately fabricated evidence that deprives you of your foster care liberty interest as well. You should always have absolute freedom from deliberately fabricated evidence by a government entity. Oh my God, I can't believe that the distinction needs to be made. You lose me at deliberately fucking fabricated.
That's huge. That's gigantic in terms of what somebody could appreciate and understand. How in the world could a person in the position of, we have to take the facts as they're pleaded in the light most favorable, so, we're not trying the case. But how could a person
Thanks, Delilah, for dropping a spicy message in the middle of this. What the? God damn it. Why would you ever record something on your phone?
in the shoes of your clients possibly believe that it was appropriate to use perjury and false evidence in order to impair somebody's liberty interest in the continued care, custody, and control of that person's children? How could they possibly not be on notice that you can't do that?
I understand the...
How could that possibly be?
I understand the argument that it seems to be common sense and our ethical...
It seems to be common sense. My man is like, how could it possibly be that they think that they can lie to take away someone's kids? Let me tell you the dark reality. In the back of every CPS worker's mind, even the good ones, even the best ones, in the back of every single CPS worker's minds is a glimmer of an idea that if they feel it's necessary, they can lie to take away someone's kids. Because you know what? They can. Let's pay attention to a couple facts. This is going to be depressing real quick. This hearing is on October 7th, 2016, right? Did you hear when this happened? Did you pay attention to the fact that they mentioned earlier when the parents lost their children? Now, I don't know when they got them back. This happened in the year 2000. This happened in the year 2000. And 6 years later, they're arguing over it at the appeals court. it would be another 2 years before the parents win this case. 18 years from when the government lied about taking their children to when relief was finally granted. In the back of every child protective services worker, even the good ones, in the back of their mind, this is not strange for them. This is how they think. And that is why CPS is one of the most disgusting, most deranged, and worst government organizations that exists. Because for every single good deed that they do in protecting a child, and they do it from time to time, there are too many awful deeds done to deprive the rights of parents and children. And you will never convince me otherwise. 13 Speed Demon says CPS is government-sponsored child trafficking. Yep. All right, let's move on.
It's more than common sense. It's statutes that prohibit perjury and submission of false evidence in court cases.
State statutes.
Are you telling me that a person in your client's shoes couldn't understand?
State statutes, yes, all of child protection and all of parental rights are controlled by state law. Like, the amount of federal law involved is abysmally small. The feds don't have jurisdiction over most family law or child protection issues. State statutes, shut up.
Understand you can't commit perjury in a court proceeding in order to take somebody's children away?
Of course not, Your Honor.
Of course not.
Then isn't the case over then?
And the case is over.
Because
Costanich is distinguishable in my view. How in the world? Costanich deals with a secondary care, foster care. That's a whole strange thing. It's not a person's real child.
even if Costanich
and guardian's the same thing.
Even if Costanich is distinguishable, there is...
Case is over, right? No, let me just continue to argue it. They're like, no, case is over.
Thus far, we have not been presented with any clearly established right that tells us that what our clients did, which is remove the children pursuant to a court order.
No, but what they're accused of doing and what the issue is here is committing perjury in a court to take away someone's children. And you just said that's obviously not okay to do.
According to our moral compass and our ethical guidelines, but what we're here to decide is the constitutionality of it. And we
look at this man's face. Look at this man's face right here. He cannot believe she's making this argument. He's like, I'm going to eat your fucking lunch the moment you shut your damn mouth. Like, well, according to our moral compass, however, not in our law. He's like, what the hell are you talking about?
We look to the courts.
You mean due process is somehow consistent with a government official introducing perjured testimony and false? How is that consistent? I mean, I hate to get pumped up about this, but I'm just staggered by the claim that people in the shoes of your clients wouldn't be on notice that you can't use perjury and false evidence to take away somebody's children. That to me is mind-boggling.
In criminal proceedings, we know this to be true because that...
No, like criminal proceedings, it's a court proceeding with a liberty interest, a fundamental liberty interest at stake.
And on the reverse side, the state...
And you're telling us that these officials who do this all the time couldn't be on notice that you can't commit perjury and put in false evidence.
I understand broadly the principle that common sense tells us that lying is wrong and lying to...
Yeah, but it's more than common sense. We're not using common sense. We're using the statutes, for example.
Common sense tells us that lying is wrong. First of all, let's be clear. Lying isn't wrong. People lie all the time, and there's nothing wrong with a lie at a fundamental level. Like, if if a fat chick walks up to you, okay, wait, no, you should never tell a fat chick that they're skinny. Look, if someone walks up to you and they're like, hey, am I the worst person ever? And you're like, nah, you're at least like above the bottom 5. It's okay to lie a little bit. Like, people lie all the time. They do these minor lies. People lie to their kids about all sorts of stuff. People lie to their parents. People lie to their friends. Oh, I can't make it because of whatever. These are harmless lies. Lying in and of itself is not a problem. Lying to the detriment of another party, that's what matters. That's biblical, right? The Bible doesn't say don't lie. The Bible says, do not bear false witness. And that is translated loosely to do not lie. But that's not at all the same thing. Bearing false witness impacts someone else in a dramatic way. It means that you offer a false testimony against someone else to their detriment, to the deprivation of their right or their property or their happiness, whatever it may be. That's where lying matters. When you deprive someone else, and the person you're lying to could be the person deprived as well. So it's not just about lying about a third party to a second party or anything like that. You could be lying about yourself to the second party. You could be lying about whatever. Like, you could say you're 6 feet when you're only 5'11", and to another person, and that seriously impairs them because they're like, oh, look, I respect you. And then when they find out you're 5'11", they're like, you son of a bitch, you stole my respect. Okay, so that's what it matters here. She's trying to be like, lies are generally bad. This isn't just a lie. This is perjury to the deprivation of someone's parental rights. And that's the key. This is about it's about violating the law, first of all, and second, doing so to deprive someone else of rights, which is disgusting. Sam Hyde says, can we just take a moment and realize there's not enough women lawyers? Yes, thank you. Thank you to Sam Hyde. Man, you know what sucks? On my old Twitter account, I was talking to Sam Hyde. And now it's gone. It's gone. He's committed like 8 shootings since then, too. Bad Vibe says, the road to hell is paved in good intentions. CPS is on a bullet train. They're the very villains they are meant to fight. Yes, CPS is terrible. CPS is terrible. All right, here we go.
Well, against this kind of behavior.
I was not presented, I have not been seeing any federal law, case law, or law that tells me that in this situation that we were faced in, which is what we have to look at.
Say your clients hired 6 people to be actors and to go into court and say, we're neighbors and we saw all this terrible stuff. And then your clients presented those witnesses in court. You're telling me that they would have no reason to believe that you can't do that because there was no federal case that says you can't bring actors into court to swear falsely against somebody.
But again, here we're appealing to sort of a broader definition of what is a clearly established right. I mean, we have to.
Okay, I think this must be in this is in federal court of appeals in the 9th Circuit. So that's because this is a 1983 claim where a government agent acting under color of law deprives someone of a guaranteed right. That's why this is in federal court, and that must be why she made the distinction between state law says this. But yeah, the federal courts are not going to. They're not going to pretend that perjury is somehow okay. This is a ludicrous case.
Find the clearly established right in the context that our social workers were presented with, which was they were faced with a court order.
Again, I can't even believe for a microsecond that a caseworker wouldn't understand you can't lie and put in false evidence.
Let me ask the question a different way, counsel. Was there anything you know of that told social workers that they should lie and they should create false evidence in a court proceeding?
No, and of course, that is we contend that that's not what happened here.
I understand. Look,
We're stuck with the facts, and the light most favorable.
And to be clear, we are only speaking that
Right.
we accept the pleadings as alleged. We are not saying any of this is true. I want to be very clear about that. But
Right.
that's what we're dealing with right now. Is there anything, I mean, look.
Okay, so they're dealing with the pleadings as assessing what's in the pleadings as true, which means they're not actually saying that CPS lied. By the way, I'm pretty sure CPS went on to lose this case dramatically. But you know, they're not arguing from the position that CPS did lie, and she's not either. She's arguing from the position that CPS has the right to lie, even though their position is that they didn't.
You've got your clients, you're doing your best to represent them here. But from our perspective, you see where we're coming from here. So help us. Okay, we've talked about Costanich, and we've said that case there's some language in there which I understand what you're pointing to. I got you. But as Judge Friedland and Judge Trout both said, it also does have a different interest. So is there any case besides Costanich that you can point to and say, here's Ninth Circuit, this is the answer?
Well, what I would contend, Your Honor, is that was plaintiff's burden to do when it came to qualify.
No, I understand that's your argument, but just for your sake, because you reached to Costanich, which if I were in your shoes, I'd be reaching for it too, as hard as I possibly can. Is there another case? You got one hand kind of on the ledge here with Costanich. Is there another hand you can grab another Ninth Circuit case where you've got a firm grasp? You can say, see, I've got it.
In terms of another Ninth Circuit case that instructs social workers to lie and cheat.
Or at least sets a time period. At least sets a time period that says, as of this date, you can't do this anymore.
Other than Costanich, Your Honor, I do not have any such case in front of me.
As a matter of fact, Snell precedes all of this, and we have cited Snell with approval on many occasions.
Understood, Your Honor. Snell did precede this.
And we've embraced Snell in our published opinions.
In the context of criminal proceedings, yes, that is true.
Snell wasn't a criminal proceeding.
I
Oh,
believe
shit.
Snell involved a criminal proceeding, an affidavit for a warrant, I believe was the underlying issue.
We can look that up if there's any question about that. But you mentioned nothing other than Costanich. Now they're going to come up and they're going to talk about the Green case, Green versus Camreta. What's your response? And look, and I will acknowledge our case law is not entirely clear on this. Okay, so I don't fault you for having to dance around these two cases. But Green, what's your response to Green?
Green does not clearly establish the law as it was in the year 2000. Green was decided in 2009, involving conduct in 2003.
But all those cases talked about conduct that it was previous to the conduct in this case. They referred to cases that referred to conduct that was earlier than what happened in this case.
Correct, but again, in the context of criminal proceedings.
But Green cites them as establishing a principle beyond criminal, right?
Right.
It does.
It does.
And
well,
you
it
know,
does.
one thing that we read in Costanich, and I understand we're sort of beyond that, but you know, there is a difference between civil child abuse proceedings and criminal proceedings.
But doesn't Green stand for the proposition that that's not true?
Even if it did, again, it is post-conduct authority that our clients would not have been aware of. And Your Honors raise a good point when you say the case law is unclear. I mean, our own district court judge made that comment that, you know, as between Green and Costanich, it was very difficult to reconcile. And I would submit that if it's difficult for courts and it's difficult for judges, it certainly would be difficult for us.
Can we back up for a second and talk about whether we even get to this issue? Because why do you think that qualified immunity wasn't litigated in the state court? Why aren't we bound by what the state court said about qualified immunity?
Well, the state court's analysis in terms of qualified immunity, I don't think was did not comport with the federal court analysis.
I mean, that may be, but isn't that not a factor in estoppel analysis? I mean, aren't we bound even if the state court got it wrong, as long as it had jurisdiction, it decided the issue? If it cited the wrong cases or said the wrong thing, we're still bound by it as long as it was decided, aren't we?
I would submit that the issues were not identical that was submitted to the state court versus the issue here. Yes, the term qualified immunity was used, but the underlying, in our view, the case law had changed.
Wasn't the issue whether lying in court to deprive a familial relationship was clearly established? They didn't say clearly established, but wasn't the question in state court whether there was qualified immunity for lying in court to deprive a familial relationship?
The question, correct. There was an issue of qualified immunity. Now, they did not do the two-prong analysis. And
Right, but that gets to citing the wrong cases. So what's the difference in the issue that was decided?
Our argument here is that Costanich changed the lay of the land. And when there is a change in the law, California courts have held that collateral estoppel cannot
But
bind
that's
us.
when the change in the law is like, is this the statute that this is about, or is that the statute that this is about? The state court was talking about qualified immunity. Now, maybe they made a mistake, or maybe you think they cited the wrong cases, but there was no issue of like, now California law under this statute is totally different. It was still qualified immunity.
That is correct, but there was a change in the law in terms of the federal qualified immunity doctrine and how it applied to the facts of this.
So the cool thing about arguing in appeals court versus in state court, well, not state court, district court. In district court or lower court, whatever the lower court may be called in a particular state or jurisdiction, you're arguing over the facts. And you're trying to convince a jury or a judge, depending on the situation, but you're trying to apply facts to law, right? So it's an issue that's a little bit hairy because you have the opportunity to convince the judge that your interpretation of the facts is correct and your interpretation of your application of the facts to the law is correct. That's a huge strategic difference between going to appeals court. She has to square off against 3 judges who are fully briefed on this issue, who have a different role than a district court judge. A district court judge does not necessarily read all your documents. They may not have time. You may not get to it. It's your job to brief them on the facts and the law at the hearing, if you've got a hearing, and to go through with it. The appellate court level is a little different. You got 3 judges. You've got 3 judges with court clerks, especially at the federal level. All of these judges have at least 1 clerk, if not 2 clerks. We're going to go through every brief, every document, every submission, and they're going to go through all of it. They're probably going to write their own memorandum of law. They're going to submit that to their judge. The judge is going to also go through this, check citations, familiarize themselves with the important cases. And you're going to argue the law with a panel of judges. You're not going to worry about the facts. The facts are as pled, and you don't need to, they're going to dismiss that. We don't need to worry about that. The facts are these. We know what the facts are. They're pled here. Don't focus on that. And that's what they said at the beginning. Now you're going to convince me on why the law favors your side in this set of facts. The good thing about that is you've got judges who have read every document that you've come across. They're fully immersed in the issues. They've read the cases. Notice these judges are citing these cases, and they're talking about the principles of these cases. They're talking about what these cases said. You don't see this at the district court, by the way. A district court judge is relying on the lawyers in the room to tell them what the cases said. The appellate court, especially at the federal level, they know what the cases say. Many times they issued those decisions if they're recent in time, or they're landmark cases from that court or from the Supreme Court that they rely on all the time. And they're going to be familiar with them, or they're going to familiarize themselves with them. It's a completely different style of argument. And that's why this lawyer is getting absolutely smoked. She has no case. She probably knows she has no case. She has no case. And these judges they've read all of this stuff. Look, they're checking their notes. The notes probably from their clerk who said, look, Green says this. This is what Green says. So she's just going to read it and go, look, doesn't Green stand for this proposition? And that's an invitation for the lawyer to say, no, it does not, Your Honor. Green doesn't stand for that proposition. It actually stands for this one, if they can pull that off convincingly. The clerk is probably a lawyer. It's probably a lawyer relatively fresh out of law school, and is probably a fresh law school grad who graduated in the top 5, maybe top 3% of their class from a major school. I mean, this is Ninth Circuit Court of Appeals. You're talking about like a Stanford law graduate in the top 3 to 5% of their class who's going to be very fresh on these issues. They've probably taken courses on it. They retain them well. They brief them well in their own things, and they killed it on the bar exam. And then they came out and immediately went into a clerkship with an appellate court judge. You're going against some sharp people here. You better be on your damn A game, and you got to know that your case is horse shit, and you've got to come up with compelling arguments. She doesn't have any. She doesn't have any. And that's to her detriment here. Look, if you're going to go and argue before a state Supreme Court, a federal Supreme Court, or a federal appeals court, or even a state appeals court, like, you're not up against one lawyer, one judge who doesn't know what's going on. You're up against 3 judges and at minimum 3 clerks, and they're all probably better lawyers than you. So you got to outwit them. You got to figure out some compelling arguments. You got to come up with some competing theories, and she's got nothing. Sam Hyde says, I was thinking, and I realized, the best type of lawyer of a human is one who is subject to emotional imbalance. Obviously, I'm talking about men, just to be clear. Well, thank you, Sam Hyde. He also says, imagine the judge drop kicks her in the face. Not really, but metaphorically.
Case.
I mean, is your only basis for that Costanich, which we've earlier said we don't really think changed anything relevant?
It's Costanich, and it's also the fact that Green, which came out after the fact, it made these connections in terms of civil and criminal child abuse.
Her argument right now is honestly that they didn't know that they weren't allowed to lie because they only weren't allowed to lie in criminal proceedings, not civil proceedings, under the existing case law. That's literally her argument.
How is that relevant to what you think the state court did? I mean, your first response is the state court didn't really look at this the way the federal courts do anyway. So if we start there, then does it matter what Green and Costanich said?
It matters because the issue has changed. And if the issues are not identical, we don't have collateral estoppel.
But isn't the issue still qualified immunity for lying in court to deprive a familiar relationship?
It is. The issue in the state court was the familial relationship of the mother. Here we are dealing with the familial relationship of the children, so that is a different aspect of the issue. There are different rights involved there. And the issue is the difference in the law, that the landscape of the law that changed after the fact.
All right, thank you, counsel. We will go ahead and you got a lot of questions, so we'll give you 2 minutes in rebuttal, okay?
Thank you, Your Honor.
Oh, please tell me the other side gets to go. Oh, this will be great. Can you imagine? You get to come up. That's like being, what? Sammy Sosa, right? And you're coming up at the plate of a little league tournament. And you're like, all right, this is going to be fun.
Good morning, Your Honors. May it please the court, Dennis Ingalls on behalf of Presley Hardwick, the plaintiff and appellee. As this court hit upon, Costanich is readily distinguishable. There are a few additional points, which I'd like to point out. Mrs. Costanich wasn't even a guardian in the probate court sense of the term. She was the dependency guardian. She was just tasked with taking care of these children while the natural biological parents' dependency case ran its course. Contrary to what counsel says.
So you wonder what kind of a liberty interest there would be in that relationship?
Virtually nothing. And if you look further into the proceedings that took place in Costanich, there was a administrative law judge who was then appealed to a CPS judge, if you can imagine such a thing.
CPS, Child Protective Services?
Right. In that case, in that state, they call it DSHS. I forgot what it meant. But they appealed it to their own board of appeals. And that person said, well, what does it matter if they lied, because we couldn't do anything about it anyway? So the nature of the rights at stake are just worlds apart, as this court hit upon. Contrary to what counsel said, Green didn't establish anything. I think the court realized this. Green said there are these older cases that established this a long time ago. Lying is bad. It's obviously bad. It's unconstitutionally bad. Pay your money, do not pass go. This case took place 16 years ago. They lied. A jury awarded nearly $5 million. They kept fighting the proposition that lying is bad. It turned into nearly $10 million, and they're still here fighting the proposition that lying is bad.
I just summarized it entirely. They're fighting the proposition that lying in court is bad.
I would simply ask their appeal be denied, and I would ask the court that you issue a published opinion so that some stubborn count in the future doesn't come back and say, well, Costanich, this, that, and the other.
How does collateral estoppel work here? It seems to be that the state failed to address one of the primary questions specified by the Supreme Court that's dispositive.
You know, this guy wasn't even going to make an argument. Everything she said was stupid. They're arguing for the proposition that lying is fine. We ask that you guys just go ahead and put it down on paper that lying in court's bad. Thanks. And then the judge interrupts him from leaving by asking a question.
That's whether the law is clearly established. I can't find anything in the state proceedings anywhere that suggests that anybody confronted that issue and decided it. And if that's true, what does that do to collateral estoppel?
Collateral estoppel still applies, Your Honor. They did not specifically use the words clearly established, and although the words clearly established were part of the case law dating back to Harlow, prior to Saucer versus Katz in 2001, there wasn't this necessary two-step where you had to have a subject heading in every opinion that you wrote as a judge. And there's the merger concept, which I outlined in my briefs, which Butler versus L, Liston, Franks have all talked about, where the clearly established component of qualified immunity doctrine is consumed by, swallowed by, merged with the deliberate falsehood question.
Is collateral estoppel something that let's say you're right about what the state court decided. Does that mean we have absolutely no latitude at all as to whether to accept that? In other words, we take a look at it and say, boy, that's what the answer was, but they blew it. They didn't know what they were doing. Are we still stuck with it?
I do think
in the federal
this case
courts?
We are bound by collateral estoppel, but even if you went past that and hypothetically said no, this case it's astounding to me this case is still being fought.
You don't need
so
collateral
simple.
estoppel.
You don't need it. The lies are on paper in a transcript, the deliberate falsehood, and the...
So there was an interesting thing the judge did there. Are you saying we don't have power? You never tell an appeals court that they don't have power over a lower court, by the way. That's a trick question. That's a trick question. That's where the judge wants you to say something dumb so he can make fun of you. And he doesn't here. He says, look, this case, it doesn't matter. But hypothetically, look, even if you could say, even if hypothetically that weren't the case, you could say that this is wrong. But in this case, it's so right that it's ridiculous. That's what he's saying. And he's navigating this very well. And then the judge, of course, yeah, that'd be crazy, right? That'd be crazy. He tells him what to say. It's amazing.
The but-for causation set forth in Franks.
Are you still
progeny.
pursuing Vreeken?
Yes, absolutely.
And what was her status coming out of the state case?
Vreeken, there was a sizable damage award ordered against Vreeken.
Against Vreeken?
I believe you
Who
might.
was the one who was exonerated?
Wilkins.
Okay, Wilkins. Excuse me, I misspoke.
We are. Yes, our claims against Wilkins are still alive. Now, the jury will do what it will, as it did in Deanna Hardwick's case. But those claims are still alive right now in this case.
Are you alleging violations of the Fourth Amendment and the 14th Amendment?
We are, Your Honor. My client, as a minor, was actually seized, so there's your Fourth Amendment right there.
Do we need to distinguish between them? Is there any difference in whether we think about this as Fourth Amendment or 14th Amendment?
No, there's no difference in the standards whatsoever.
Okay, the Asian chick right now knows, I mean, she knew she was losing coming into this. Let's make no mistake. But the fact that the judges don't even have questions for this guy, like they're conferring right now to find out if there's anything else they want to ask. You notice there was no hesitation during the other party, right? Like they're asking questions constantly. This guy, they're like, oh, what do we got to ask? We agree with everything he said in his brief, and everything he said up here is fine.
Unless you have anything else, I think we're good with questions for you.
One other little point is that California Government Code 820.21 has been on the books since 1995. It's 820.2 tells government actors in the state of California you get immunities for using for discretionary acts. 820.21 came out, it said, unless you lie, cheat, and steal. So don't do that. With that, I would rest.
By the way, in 1995, they just clarified it. The government can't lie.
Thank you, counsel. All right, you've got your rebuttal time.
I don't want it.
With regard to Mr. Ingle's last comment on 820.21, that is a state law. It does not bind the federal court in terms of what is constitutional and what is not.
Doesn't that weigh on the question?
She's going to come in and be like, look, it's a state law that says you can't lie, but that doesn't bind the federal court in saying that the state actor can't lie under state law or whatever. What a terrible argument this is.
Of whether something is clearly established that an official could understand what the official could and couldn't do?
It could.
I mean, in Hope versus Pelzer, to go back to that case again, they use all kinds of things in that case to say that it's clearly established, not just cases that have been decided by anybody.
Yes, Your Honor, that is true. A court is entitled to utilize several factors.
So why isn't that what he said significant?
Individuals are not bound by our own individual sensibilities in terms of what is right and wrong. We are bound by what the courts tell us are clearly established law, whereas the courts can rely on other factors.
I can't get over this man's stone face. He's looking at her like, what are you talking about? How are you seriously still making this argument? That it's okay that they lied. They're told in a law not to lie, and you're telling me now that I don't have to pay attention to the law that says they shouldn't lie? God, hold on. I gotta go back. Just a second. God, look at his face.
By what the courts tell us are clearly established law, whereas the courts can rely on other factors to tell us what clearly established law is.
Are you telling us that your clients don't have to pay any attention to the California government code?
Absolutely not. They absolutely do. But here we are in federal court on a federal civil rights action deciding what is constitutional and what is not.
And what case prior to Hope v. Pelzer said that you can't tie someone to hitching post?
I am drawing a blank, Your Honor. I'm sorry.
I think the point of Hope was that there wasn't a case exactly on point, right?
Exactly.
So we don't have an exact case here saying that people can't lie to take kids away from their parents, but Hope says we don't need one.
We don't need an exact case, but we don't define our constitutional rights broadly. We need clearly established law.
We don't define our constitutional rights broadly? Yes, we literally do define them broadly, you dummy. What are you talking about? Constitutional rights are defined broadly and narrowed sparingly.
That tells us how to act in the context that we are.
So why isn't the government code significant and relevant?
It's in my view, it is not. State law does not dictate what is constitutional and what is not.
It doesn't dictate, but it adds considerable evidence to the question of whether your clients would have been on notice. You can't do this.
It could. It could.
I mean, it's not just what somebody told them in a conference. It's state law under the government code.
That is true, but that's not what happened here. And we haven't been presented with any law telling us applying this particular state code.
Okay. That's all that there is. We don't get to hear the end of her argument, but I think you could see how that one was going. Spoiler alert, she lost. Spoiler alert, she lost dramatically. I mean, the very idea that you would, with a straight face, get up and argue to an appellate court that state law telling state actors in the state where the law is that they can't lie in a court proceeding didn't put them on notice that lying in a court proceeding is bad. Like that's the proposition that she's ultimately going for. There's a state law saying you can't do this, and them saying, yeah, but that doesn't tell the state actors who are specifically referenced under that law that they can't do the thing. It was an interesting approach by Asian lady. Not very effective though. Whew, that was rough, man. I would never want to be in her situation. The real question is, why are they appealing this case? Why are they appealing that decision? Whoever in that office is making the decision to appeal there, and let me be clear, but the office is CPS. The government was making the appeals decision there and telling their lawyers, we want to go through with the appeal. The lawyers had almost an obligation to say, please, dear Christ, don't make us get up there and argue that you can lie to take away kids. That makes us sound like the worst people on earth. And the government, of course, saying, checkmate, we are the worst people on earth. Right? Like that's what happened there. Anyway, I hope you enjoyed that. I like going through these court cases. So if you guys ever have like a funny court video or an interesting court video, let me know. You know, chances are the only reason I don't do more of them is because I don't sit around looking for them. But if I find them and they're interesting, I like to go through them. I think they're great, but I don't go around looking for them because that's not part of my daily research. But if you guys have them and send them to me, I'll always consider doing them. I think they're great. Lots of fun. God, I gotta bring my cat picture in. You did not enjoy the content of the video? Me either, Dead Snake. I hate CPS with an unbridled passion. I think they're terrible. And this is coming from me. I was a foster parent. I was a foster parent in that system. And I hate it. I hate everything about it. I hate the foster parent training. I hate the stuff that they do to parents. It feels like as a foster parent, you watch them take kids from homes that have hope and leave kids in places that seem hopeless. And it's an ugly mess. Everybody knows they don't have the resources, they don't have the training, and they don't have the knowledge to do what they do. Yet they do it anyway. I hate it. I hate it. I was glad to be an attorney. As an attorney, I can't really be a mandated reporter. So once I became an attorney, can't really be a foster parent because can't really be a mandated reporter because a mandated reporter doesn't really work with attorney-client privilege. So, should we send you sovereign citizen court vids? You can, but sovereign citizen court vids get old. But I'll always take a look at them and consider them if they're funny. We can look at them. Xander's Rant says you gave Lee Beard all your tech issues today. Also, when are you going to play Among Us with the Beards? I don't know. If they invite me, I'm happy to do so. Porsky says, what are your thoughts on the 1957 film 12 Angry Men? I really enjoyed it. I really did. I haven't watched it in probably 21 years now. I haven't watched it 22 years. But I enjoyed it when I did watch it. Edris Rex says, forgive me for my weakness. After a year of simp sobriety, I gave $40 to a VTuber. I'm back to 2 days of sobriety. I feel awful. Edris Rex, if you're going to break your simp sobriety, you break it here, damn it. That's what your therapist told you. Come on now. Night of Hope X says, could you imagine if you could sue people for your emotional damage? Melinda could sue her mom for emotional damage, and Ron could sue Monica's cock for it also. Malik says, I love how Scott waved her credentials around in her documents like that's going to sway anyone's decision when she literally self-owned herself by saying she was a dropout. Anyone who's been through any sort of schooling is going to immediately stop reading. Night of Hope says, we in an American USA society, this bitch is made of memes for real. What an aggressive retard. Jeez Louise. Malik says, I guess she just has an issue that there's a corner of the vast internet that makes fun of her in a comparatively tiny space she doesn't even hang out in. Someone is always making fun of you, Smelly Melly. Come to terms with it. Guys, look, I've talked to some delicate people, some special people. Anime voice actors. Right? I was talking to an anime voice acting person. I won't disclose whether it was male or female. An anime voice acting person. I was talking to him on the phone, having a good discussion, and they saw some people saying some nasty stuff about me. And they had some nasty stuff said about them, right? A little bit. And they said to me, they said, Nick, how do you deal with people saying negative stuff about you? How do you handle that? Because I'm having a really hard time with it. And I said, hey, person, for me, and it's even way different for you, but for me, for every one person who says something negative about me, there's at least 100 people who have something positive to say. So who cares what the one person says? I've got reinforcement from hundreds, thousands, tens of thousands of people. Why am I worried about one person or 10 people or even 100 people? Who cares? Who cares about 100 people if you have 10,000 people? And they said, wow. And for them, that was mind-blowing. The moral of the story is voice actors have been coddled and free from ridicule forever because the anime community is full of effing simps for the most part. However, that's been changing over the last 2 years. Really have. But I want to let you know that the anime voice actors getting a fraction of criticism that normal people deal with on the average day is devastating to them. It is emotionally destroying to them. They are the most precious people on the planet. And it's a little bit funny to me. I'm dying. These people, if you go on and tell them they're bad or stupid or whatever, every single comment that they get, it cuts them to the core because it's not unending praise and adulation. They're so spoiled and so coddled and so fragile. That's why they block everybody. They literally can't take it. And all the chicks are fat. Boom. Boom. Okay, back to it. Let's see. Night of Hope says, dude, if Oprah became Bill Cosby too, my life would be complete. While I don't hope children were harmed, holy shit, do I hope we find out if they were. I'd laugh my actual ass off. I can't wait to tell every Oprah tart how full of shit they are for loving her. Malik says, hey, Gibson, giving you a big F, my man. That shit was embarrassing, and you didn't even have anything to do with it. Down that whole bottle tonight, bro. Elmo says, come on, then. Skin that smoke wagon, jerk that pistol, and get to work. Angry Kurt Russell says, that red menace Elmo stole my line. You called down the thunder, and now you got it. You tell that cur if I find any puppet wearing red fur, I'll kill it. You tell him I'm coming, and hell's coming with me. Hell is coming with me. There you go. There's Angry Kurt Russell, I guess. Night of Hope says, bitch, the reason we don't have a federal court ruling on this shit is because it never occurred to someone to be stupid enough to appeal the idea they should be allowed to lie in a court proceeding. Them not getting away with it is why there's no case. Malik says, adding to that, Nick on voice actor troubles. The other thing is these people that have the negative shit to say ain't the ones giving you money or supporting your source of income. Literally fuck what they want to say. Well, yes. I mean, that too. That too. Luminaire says, True Lies is on Prime. Watch party win. Soon, my man. Soon. I love that movie. Funny Valentine 2020 says, Nick, your top five most punchable faces. Fiction / IRL. All of them are Nicholas Sandman, the most punchable. No, Greta Thunberg. David Hogg. That's 1 and 2. Greta Thunberg, David Hogg. After that, who do we have? Got 3 to go. Fiction and IRL. Xander from Buffy is number 3. That piece of shit needs to be punched right in his goddamn jaw. Number 4. Number 4. I mean, Ron Toye, he's got to be on the list. And then number 5, I'm going to go with most punchable face. Rihanna. And that's, look, I got advice from Chris Brown on that one. Angel Rin 89 says, Emmett Plant, part-time perjurer, part-time sex pest. Yeah, by the way, let's be clear on this. I forgot to mention this. Thank you for bringing it up. Emmett Plant, who we talked about earlier, was basically canceled by his Discord server for making unwanted sexual advances on women over and over and over again. Part-time sex pest, full-time Vic will never remember him, is trying to get Vic canceled from a Trek convention in Las Vegas. He's so pathetic. Yes. Wolfgang Deo says, upside down thumbs up for Nick, you bigots. Nathan Marcano says, what is your alcohol of choice? Dude, I like whiskeys, man. I don't, and I'm not biased. I'm not sexist on whiskeys. Look, you give me a good feminine whiskey and I'm gonna enjoy the hell out of it. I'm gonna take in the curves, smoothness, the supple legs that it leaves on the glass, right? Like that's a feminine whiskey. This is not a feminine whiskey. This is kind of not great whiskey. This is the last of it. This is that Compass Box Peat Monster Arcana. We're finishing this up. But I'm down to try anything. If I had my unbridled choice of whiskey, it's actually less complicated than you think. I love a Lagavulin 12-year. There you go. Padre Speak says, soy voice. Really? Wow. Okay, I'm going to go now. Thanks, Padre Speaks. Wolfgang Deo says, when I do nothing, I do more than Emmett's Prime. Nardo Polo says, I hear Roddenberry pulled out. He's buried in his work. Come on. Raging Golden Eagle. Hey, what's up, RGE? Says, I have an IMDb page under my real name. Was in the special thanks of a movie. Oh, cool. Very cool, RGE. Now the quest is to find it. Breck Nichols says, Nick, please, oh please, do a 3-hour seminar on Roe versus Wade. Planned Parenthood versus Casey would be greatly appreciated. Oh, God. We'll have to do a bottle of liquor and abortion jurisprudence at the Supreme Court level. Ninja Work 111 says, did that kid calling you unprofessional F off? Kind of disappeared. Ben Miller seemed to disappear in his gay Hyundai Elantra that he's had for quite a while. He must have driven off from that. So Big T Armada says, Geode. Dude, I love Geode. Are any of you geologists, amateur geologists, rock collectors, whatever you want to call yourselves? Man, geodes are cool as shit, aren't they? God, I used to buy geodes when I was a kid. I would save up my money and buy geodes because I liked getting beat up. So. The gray one says, "Evening, Nick. Hope the last few days have been well since I was last able to join you live. What all have I missed? Anything absurdly interesting?" Everything is always absurdly interesting. We had Ty Beard on Saturday, and then Parlor versus Amazon on Thursday. Hopefully you saw one of those. Other than that, I was gone on Friday, and yesterday I was not feeling well, so I kind of waited. I waited the voice out. So I didn't sound like Marlon fucking Brando. Kuranite, Ninja Work 111 says, "How is the voicemail class going, Nikki? I still don't know what to do properly." Kuranite 6942 says, "Lord blesseth the lolcows, for they give many lulls." Jackie Randazzo's says, "For the Frankie Avalon." Oh, thank you. Thank you. Law school dropout. Wolfgang Deo says, "Read subtly. Get back in the kitchen, woman. Get back in the kitchen, woman." Women love being told what to do. Zephael says, "Nick, you gave a warning about drinking long ago." He follows up and says, "Got drunk one night and ended up with a 4th-degree assault. Don't remember any of it as they gave me special K. Prosecutor stacked charges. Your advice was good." Oh, man, I hope you beat him. I hope you beat those charges. Cheers to you, brother. Bad Vibe says, "Hey, if anyone is interested in Comicsgate stuffs, check out Tank Ferret. He just finished streaming, so check him out." Speaking of Comicsgate stuff, right now, Preston the Pegged is undergoing some interesting stuff. I haven't really talked about it, but I've seen some stuff floating around. Basically, people on Preston's server have been sharing LollyCon, which kind of looks pedophile adjacent, at least, on the Discord server. And there's that, and there's also some issues of Preston trying to get Ethan Van Sciver in trouble with the New Jersey police with an angry letter. He shared a porn tape of me getting pegged by a woman that I simped for. Oh, like, look, guys, cops are cops. I need to do this. I'm going to survey. I'm going to go around and ask the cops I know. Say, listen, as an officer, if you got a report where a guy said, "Hey, someone's out sharing my video of me getting anally reamed by my wife," what would you do? And then I'll just have, a laugh versus not laugh percentage. That's all. That's all. We're going to figure that out. Nightwave Radio says, "I got remonetized." Can you believe that? Mersh, you got remonetized? Bless you, brother. May Allah smile upon your channel. I am happy that you did. Guys, check out Nightwave Radio. I've met Mersh a couple of times, and every time I meet him, it's an absolute delight. He's really a funny guy, fun to hang around, and yeah, check it out. If you like it, great. If you don't like it, well, you don't have to. But at least give him a shot. He's a funny guy. He's an interesting guy. Has a really great life story. A really interesting life story. A life lived differently than many people. And yeah, give him a listen. No One Important says, "It's only Monday, but calling it now. This is the best stream of the week. That phone call thing was the most hilarious thing I've seen in a while." Phone call. Oh, yeah, the phone. stream. Mega Mobas, thank you for the donation. 200-watt Studio says, I'm actually attracted to Deborah Davis. She was decent. She was decent. Phantasmagorical says, dude getting cuffed is the greatest thing ever. God, that's funny. That's funny. 200-watt Studio. Mr. K, what's it called? It's called Nightwave Radio. Nightwave Radio. Mersh is the guy. Also, Revenge of the Sis. Revenge of the Sis is Mersh and the other guy. Royce. Royce. I love you, Royce. Sorry, I forgot your name. I'm bad with names. It's not your fault. Mersh and Royce, Revenge of the Sis. But Nightwave Radio is Mersh's solo show. Both of them. Go check them out. Go check them out. 200-watt Studio says, I'm on all fours, Your Honor. Angry Bainling says, woo! Delilah is based. She loves iced coffee, unlike you tea-loving heathens. I'm going to go slide into Delilah's DMs. Tea lovers need not bother. Who the fuck is Delilah? Angry Bainling, what are you talking about? Who's Delilah? Don't give her fucking scissors. Wolfgang Deo says, compelling argument. Just win 2-1, maybe 3-0, and flash your Hooters, gal. That's the only way you could potentially win this case. Possible. Siren Jack says that argument was still more successful than her driving. Siren Jack, no. No. The iced coffee lady? Who the fuck is the iced coffee lady? Who is the iced coffee lady? What have I missed? Delilah. Oh, Delilah texted during the appeal. Okay. Sorry, I forgot. Thank you. Guys. Short-term memory loss is real. Ace of Spades says, blessed are those women who have a small forehead. Can I get an amen and a women and a children and a person and a thing and a cat and a dog? So saith the Lord. Wolfgang Deo says, it's nice there's 100 people that may like me. However, it takes one to really hate me to dox me and kill me. So bring it, world. Tombstone. Ace of Spades says, subs are better than dubs. Only a handful of Western VAs, and these are the facts. And Nick, of all the people I simp for, you get the most from me. Hey, thanks, Ace of Spades. I appreciate it. Hooters Girl number 370 says, do you lick or bite soft serve ice cream? Lick only. You're a Hooters girl. You know this. You know this. You're a real Hooters girl. I saw a video of it was called Embarrassed at Hooters. And it was some poor, 9-year-old kid on his birthday having to fucking hula hoop while a bunch of stacked Hooters chicks sit around him and make fun of him for not hula hooping well. And by make fun of him, I mean they sang happy birthday to him or whatever. But I was like, God, this kid is just starting to get erections, and these Hooters chicks are ruining his entire life. It was great. But no, I lick soft serve ice cream. Thank you very much. Jackson Kai says, an honest question. If people are so sensitive to criticism, do they realize you can just walk away from the computer? No, they don't. They don't. Used to debate people that outside spam blocking is pointless as I can ignore it. No, they don't realize that they can just walk away from the computer. They can't. Let me correct you. They do realize that they could walk away from the computer. They can't walk away from the computer because voice actors and actresses in particular are addicted to adulation and praise. It's why they work for so little money. They're the same as teachers. I know it's a spicy take on teachers, but let's be real here. Teachers have a hard job, and people won't go through what teachers go through to make the money. Now, unless you're a private school teacher, you might make $150,000 a year, whatever, if you're particularly qualified. I'm talking public school teachers making $40,000, $50,000 a year. They're working really hard. Got no support. They're dealing with shitty asshole kids who hate them. They don't do this for the money. They do it for the virtue. They're the teacher, right? People like teachers. Teacher's a desirable position. It's beneficent, and that beneficence translates into an intangible value for the teacher. Same with voice actors in a different way. Voice actors, they thrive, and actresses. This is not limited to voice acting men at all. In fact, I would argue that it's as prevalent, if not more, amongst women, but they love that they're treated like royalty. Despite these people make no money on their work. All of their money comes from convention appearances where they do overpriced signatures. I cannot imagine charging for a signature. If you see me at a convention, okay, and you want me to sign something because you're whatever, just come up and say, hey, can you sign this? I will sign it. Of course I will. I won't sign a penis, but just about anything else I'm going to sign. You want me to sign a football? You want me to sign a magic card? You want me to sign whatever you got? I'm going to sign it. Of course I'm going to sign it. And I'm going to do it for free. Now, a couple people have demanded to pay me for a signature. I don't collect signature money. To me, it's strange. I'm just a weirdo on the internet. I will sign shit for you, of course. If you want my signature, that's fine. These people thrive on the fact that they can charge money for their signature. They thrive on the attention, the laud, the adoration, the praise. They thrive on it. It's what drives them. Their real job that they do, the voice acting from anime, most of you make more money than most voice actors. And that applies even if you're minimum wage. From the voice acting gig, all of their income comes from outside stuff, appearances, endorsements, voice acting classes. Did you see these motherfuckers? These Funimation in particular, by the way, registered as teachers to jump ahead of the COVID vaccination line. These vacuous fucking vampires are jumping ahead of old people who might actually need a vaccination to live through Cuomo's bullshit because they're fucking teaching virtual online voice acting classes. The biggest scam in the fucking country. These motherfucking cowards. They're teaching voice acting classes. If you pay for a voice acting class from this day forward, from today forward, if you pay some fat fucking bitch in Texas to teach you how to voice act, unsubscribe from me. Get the fuck out. If you're going to give them $500, $1,000, $5,000 to teach you how to voice act, get out. Get out. I don't want you. Be gone. Get rid of you. Get dragged behind a fucking Roman chariot. Get out. You simp. You dumbass. Don't ever, ever, ever pay these untalented fucking hacks to teach you how to voice act. They're not teaching you shit. They're not teaching you anything. They don't know fucking anything about voice acting. They don't know anything about it. They're not getting in on talent. It's nepotism and opportunity. Period, period, period. Anybody on earth can voice act. Anybody on earth can voice act. You want to voice act? Here's what you do. You get a microphone and you fucking talk into it over and over and over again. You work on your voices over and over and over again. Listen to some fucking stupid voice and repeat it over and over and over again. That's all voice acting is. There, I saved you $5,000 of listening to some fat, unwashed hag who's starred in one anime ever try and teach you how to voice act. They don't know how to voice act. These fucking people are insufferably embarrassing. Just talk over and over and over again. That's all it is. That's all voice acting is. 99% of being a professional voice actor is an opportunity. That's it. These people are vampires sucking the blood out of hundreds of people. Fucking fans who would desperately give anything to be on voice acting. They're like, oh yeah, if you just give me $2,000, I'll teach you the tricks. You're never going to voice act. That's the rule. You, me, everybody else you've ever met, you will never voice act in an anime. Ever, ever, ever. May you please, with God and Allah's combined blessing, break the fucking rule. You're not going to. That's the reality. And if these assholes are going to grift you out of thousands of dollars selling you on the dream that you're going to be the next extra in Bleach, for Christ's sake, you won't. Because they're just going to hire the people who are already there. And even if you got it, it'd be less money than working at fucking Walmart for a day. Stop listening to these people. If you want to voice act, start voice acting. Team up with an animator. Team up with an artist. Make something new. You'll make 1 billion times more than these fucking rejects. Let's demystify this goddamn profession. These people are the worst, most embarrassing, talentless people on the planet. If they had a shred of dignity or honesty in their bodies, they'd tell you that. Instead, they're selling fucking classes. Jesus Christ. I'm so tired of these people. Nisa now? Nobody scammed me like I'm gonna pay a goddamn dollar to one of these talentless hacks. But I know people. There are people in my Discord who have been suckered in by it or who are thinking about being suckered in by it. Fans of this show. We got a lot of anime crossover here. I know a bunch of people who have either thought about giving them money or who have given them money. And I hate hearing that. I hate hearing it. I hate it because I hear them talk about it. That's why I say from now on. After you've heard this rant, from now on, unsubscribe from me. I'm not even kidding. Here's not the place for you. A couple people have been suckered in beforehand. You know, a couple years ago, the luster of these voice actors and actresses. I got it. I understand. You got bamboozled. That's on them. They cheated you. Now you have no excuse. Here's all I'm saying. Met plenty of people, and all of them say the same thing. Oh, they helped me understand my inflection. An audio engineer, an audio technician. By the way, someone I need to hire. An audio technician is going to tell you infinitely more about how to sound good for voice acting than a voice actor will. They're going to tell you about mic discipline. They're going to tell you about the different types of mics. They're going to tell you about plosives, vocal dynamics, how you engage a microphone, how that sounds, how they're going to tweak those sounds and make them good, make them level, make them different, whatever they need to do, what your voices sound like, how you listen to yourself, how you're going to engage your own voice. A sound engineer, an audio engineer is going to be infinitely better than a voice actor. Because the sound engineer makes the voice actor sound good anyway. Don't pay these people. The worst people on the fucking planet for trying to convince a bunch of kids that for just $5,000, they too can be in their favorite anime, knowing full well that that person will never, ever be in an anime with their company. Never. I fucking hate liars. You know, like I get a lot of shit on the internet, okay? Let's break this down. I get a lot of shit on the internet. That's fine. One thing you will never find me doing, and if you do if you find me doing this, I give you full permission, unsubscribe and leave me in the fucking gutter. Will never, ever lie about anything. Why would anybody go on the internet and fucking lie about something when it can be fact checked? They can be checked. I might make a mistake. If I make a mistake, call me out. You know what I do when I make a mistake? I make a video on it. I put it at the front of, if it's like in a live stream that I lie, I'm going to put it in the front of the next, or not lie, make a mistake. I'm going to put it in the front of the next live stream. If it's in a major video, I got something wrong in the Rudy Giuliani and Trump video that I did where they got sued. I got a big issue wrong. I immediately unlisted that video, posted a subsequent video correcting it. Integrity, man. It's the most important thing you have. Your word. Your word. The value of what comes out of your mouth. When everything else you have is taken away, you've got no money, you've got no job, you've got no family, whatever it is, you're on the fucking street. The only thing you have is the value of what comes out of your mouth and you standing by it. I will always stand by what I said or correct a mistake. These people lie constantly. Don't suffer liars. There are too many honest people out there to suffer a liar. That's what I got. That's what I fucking got. Ace of Spades says, and God will send you down and cast your eternal soul into the lake of fire. It's warm, it's hot. If you pay for classes from VAs, from those talentless hacks, if they trick you into this, then he, the deceiver, Satan, the Lucifer, the golden child, the morning star, he's already won. He's won your soul, and you can't allow it. You can't allow it. Yes, you gotta stop it. You gotta stop it now. All right. All right. Nova Zero says incorrect, Nick. Voice actors don't leave because of the ungodly need for an oversaturated adulation. They don't leave because they're unimaginably fat. Unimaginably fat. Huge, even like big enough that Biden calls them out. Ugh. Burnett says, did you ever investigate your Polish heritage? Ever wanted to visit? I'll be down for a shot with you in Warsaw. Bernitz. I hope that's how I say that. Investigate, no. I mean, my grandfather was unapologetically and unabashedly Polish. That's a significant part of that. Have I ever been? No. I would love to go to Poland. It's on my list of places to go. I will let you know if I'm ever going to Poland. Believe me. Me and Lady Rackets in Poland would tear it up. It would be a great time. I'd love to do it. Spectre06 Gaming says, budding geologist. My favorite game system was the Neo Geode. Come on now. Kinnell living his 2-inch dreams says, where the white women at? Hail drunk 3PO. Philip Callan says, at least there's a small variety in male VAs. Female VAs are all 40-year-old ladies on helium, except that Simpsons VA. She's cool. Joshua Sanabria says, I watched the dubs, and honestly, I couldn't name a single voice actor. I just watched for the fast movements and bright colors. The reason I watch dubs when I watch dubs is because that show, I'm doing something else while I watch it, and I can't read the screen. That's it. Wolfgang Deo says, come on, Nick, spit it out. Let the wrath go forth. Philip Callan says, why would I want to pay for a lesson in delivering lines without soul? Most Western anime VAs literally deliver lines like Microsoft Sam. Fuck. Angry Baneling says, okay, I'll unsubscribe. I was paying this guy, Nick Ricada, for Kermit voice acting lessons. I'm going to go jump into a pool with excess chlorine now. If I was going to do voice acting lessons, I wouldn't charge for them. You just move your voice back to here in the back of your throat, and you add a little bit of vocal fry and linger on some vowels, and then you add a little bit of Jordan Peterson. You wash your fucking balls, you bitch. That's all you do. That's all you do. And maybe you can't do a Kermit voice. That's cool. There's a lot of voices I can't do. Rekka Wronghouse says, Nick, love your rants. They are great, and I agree with that rant. Oh, by the way, you rhymed without realizing it. Thus, you're now a leprechaun, bro. Good. Good. Phantasmagorical says, I was going to ask you to give me Elmo voice lessons. You can forget it now, Lamau. I'm kind of scared. No, I'll just tell you how to do Elmo voice the way I do it. That's fine. I had to read a bunch of books as Elmo to my kids, man. That's how I do it. Bad Dragonite says, proof, go watch Baldermort 0 voice acting lessons. Gordo Fabulous says, here's $5 for using suffer to mean tolerate. Oh, hey, thanks. My pleasure. My pleasure. Here we go. Let's see. I'm trying to figure out where I left off. Melinda Scott says, I don't know what's going on, but every time I do anything, my finger and my thumb naturally make an L shape and it gravitates towards my forehead. I feel like this is indicative of my life, but at least I've gotten laid by the whole class of 2004, so ha! Malik Foxon says, adding to that, Nick on voice actor troubles. The other thing is those people that have negative shit to say ain't the ones giving you money. Oh, I read that one. Or supporting your source of income, literally fuck what they want to say. As Cybertaz says, Goy is banned from the chat. They know. It's not banned by me. It's not banned by me. Wolfgang Deo says, so you would, can I pay you to sign my penis? No. Night of Hope says, sign Jamie Markey's fat cunt. If you lean over, you can almost reach it from there. That's disgusting. No, I don't sign anything that smells like rotting cheese. Malik Foxton says, how do you make top grifter last year? You're passing up prime grift opportunity. Charge $100 a signature, fam. Look, I don't need these bullshit tactics to make top grifter. Wolfgang Deo says, if you don't like me paying for voice acting classes, how about you come over and click the unsubscribe button yourself? Oh, I will. He says, I swear that I have not attended and never will attend voice acting. I forgot my /S on the last message. Please don't be angry at me, Daddy. Porsky says, look, I'm not one to get suckered out of money, present transaction notwithstanding, but I'd still one night stand the Texas redhead. She's a redhead after all. There, I said it. Shame me if you must. Dude, she's not a redhead. One, that's fake red hair. Two, she's fat. Those two things are a problem. Taybebe26 says, hey, Nick, back in 2010, I went on to a video game mod site and auditioned for a role. Ended up getting it, and am now in the video game mod. Ever since, my friends and family have hired me to do audiobooks and such. You don't need anything but what you said. Do it. Do it. That's the trick to voice acting. Do it. Go do it. Go do it. That's what all these people did. None of these people took a voice acting class. They didn't take a voice acting class. They just went and auditioned and did it. They got lucky and they took advantage of an opportunity. That's all. That's what it is. Porden G. Betterson says the left is going to win the culture war if you don't clean your room and your balls. Damn. Damn. All right, guys. Thanks for joining me. Thanks for making this a fun show. I appreciate you guys hanging out with me. We're going to go over onto Twitch. We're going to watch Rat Race. And then I'm going to go to bed. I hope you guys enjoyed this. Thanks a bunch. We'll see you tomorrow for some different subjects, different talks. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed